Greetings, fellow humans of the world and of the Commonwealth. We're here today with Mr. Paleo and how to apply the Magna Carta. Uh, I think before we'll start, I have a prayer to. I want to do a prayer, just because it's Ramadan, and I think the times that we are in, we need all the protection that we can get, especially those who do want to do harm to us. We pray that the Lord have mercy on us, on mercy on them as well. Um, I'm gonna do the Arabic prayer, actually, the first 8 verses of the Quran. So here I go. Subhanaka Allahumma wa bihamdika wa tabarakasmuka wa ta'ala jadduka wallahi yaruk. Auzu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. Rahmanir rahim. Maliki yawmiddin, iyyaka na'budu wa iyyaka nasta'in. Ihdina siratal mustaqim. Siratal ladzina an'amta alayhim ghayril maghdubi alayhim waladdallin.
Amen.
Amen. Lord, we pray that you humble us today and give us discernment in reading this holy document of the Magna Carta. And that I also, Lord, that you protect us from any wrongdoers and any detractors that may try to get us away from the straight path. And that, Lord, today that you protect Travis and guide him through these turbulent times as he's being incarcerated right now, and that you also protect him as well. Amen.
Amen.
All right.
Amen.
All right. Okay, let's do this. Okay, so I'm going to screen share here. Can you see my screen?
Yes, I can. Yes.
Okay, I'm going to start the show here. Okay, so the Magna Carta. So this is the history behind the Magna Carta. Binding upon the crown since 1215, when it was sealed by King John and the 25 barons in the meadows of Runnymede. King John became the first monarch to be excommunicated after opposing Stephen Langton as the Archbishop of Canterbury. King John also seized portions of land for tax revenue in 1214 in his failed invasion of France. So this was basically taxation without representation, and from that there was a consequence. It sparked a revolt of the barons in 1215 of an all-out civil war. So what King John did is he sealed the original document of the Magna Carta with the 25 barons committee. Few weeks later, Pope Innocent III annulled the document, and then after the death of King John in 1216, it was reinstated by King Henry III. He was 9 years old at the time, and then it was revisited 1216, 1217, and then the last version was made in 1225. The significance of the document. So this has implications all around the world. It's been used for UN Universal Human Rights Declaration. the Bill of Rights, the American Constitution. There's actually a story. Maybe you might like this, Paleo, or any Americans that might be watching. That Philip Koch was inspired uh, the American Constitution. The Americans were inspired to make the Independence Declaration off of his interpretation of the Magna Carta. So you guys maybe can research him a little bit more. It's also inspired the Canadian Charter Rights and Freedoms, helped form First Nation treaties in Canada. The document was most recently invoked by the 25 Barons Committee March 23rd, 2001, as it pertains to petitioning the Queen to withhold royal assent over the Treaty of Nice. So the Treaty of Nice was a treaty where it was between. It wasn't of. It was as a EU agreement where basically the barons looked at that treaty as it would undermine the clauses of the Magna Carta, and it would fundamentally change the fabric of law in Britain as it pertains to trade, immigration, and just basically conducting losing sovereignty, English sovereignty. But royal assent was granted by Her Majesty anyway, despite these letters. There's actually a record of letters between them back and forth of this proof as well too. So with that said,
John.
Yeah.
Is the letters from who back and forth?
Is between the barons and Her Majesty.
Yeah. Recently, right?
Yeah, this was they started writing on February 7th, because it was 40 days, right? So they write it back and forth, and then they were basically petitioning her to withhold royal assent over the Treaty of Nice, and that royal assent was still given by Her Majesty. Thus, they invoked the Magna Carta with the 25 Barons Committee. And then all clauses apply to any citizen who is a member of a Commonwealth nation. So that would be England, Canada, Australia, Jamaica, New Zealand, and so forth. Either private or a member in good standing with the corporation, i.e. a federally registered party. Any questions so far?
Yes. I want to know about the corporation. The corporation is the thing. Is the body that registers parties. What do you mean? Explain the corporation to people who wouldn't know, because I don't know what the corporation is. So explain the corporation to people who wouldn't know.
A corporation is just a legally registered corporation. So if you're for example, a federally registered party, you need to submit documents. So you need to submit 250 registers. So you basically have to follow the legal structure in order for you to be a whatever that might be, business or a political party. In a corporation, the individual and an office are interchangeable with each other, and I'll actually go into that as well too. So I will touch on that. But yeah, basically, as long as you have legally registered as a corporation, and if any undue injustice has been done to you by the crown, you can swear an oath to the 25 barons.
Okay. Hey,
Yeah.
For the I just want to say salam alaikum to brother Tehran. Tehran, he's in the chat. He said salam to the chat, so I want to say salam to him. And next thing, okay. So every party has to register as a corporation first and foremost. So what is the significance of it being a corporation? Does it being a corporation? Does that make it Does that give it a certain is that give it a certain legal device like erasing to the
Yeah,
crown charter or something from the crown? And so it gives the crown authority like go into the nature and the speciality of corporation a little bit more.
like a corporate body, like a like just like a business or like a party, just like it's like a it's a legal entity in and of itself, and with that, a person can
It,
act on behalf of the corporation uh,
yes.
to extend its interest um, in any sort of way, and with that too, you can also uh, because a corporation legally it's bound to expand itself. So anything that is lawfully binding upon the Magna Carta, you can expand the corporation in any way, and that includes seizing civil assets.
Okay, a corporation is bound to expand. I don't get that.
It's
What?
legally obligated to expand itself. But I think like I don't know, we're trying to get in a little bit of the weeds here. Like I kind of like I don't know, like it's just basically like with regards with the Magna Carta, like it's you can either be a member of a like a corporation, so that'd be either private or like you could be a private business owner, or you can be a member of a political party, uh, and as long as you meet those specific definition, like as long as you meet the legal bounds, as long as you register, like you get a business license if you're like a small business, or as long as you follow the rules and you get the necessary signatures and legal paperwork submitted as a federally registered party. Therefore, and then therefore you are a registered corporation. And as long as you are a member of good standing, so as long as you're a member of good standing, so as long as you're like an employee, like if you're an employee of a private business, or if you're a small business owner, or even a big business owner, if any undue justice has been done unto you, you can swear an oath to the 25 barons.
Okay, because okay, don't worry about it then. Okay,
Yeah,
okay.
yeah. I'm like, it's not like this. I'm not like
No, no, no,
I didn't
wait.
sit to talk around corporate law. Like I will actually mention more about that at the end, but like, yeah, that's
No,
basically the
no,
yeah. That's
no, no,
just
it's
you know
okay,
what
it's
I
okay,
mean.
it's
Like
okay.
you don't want to overthink it, right? Like I don't know. Like yeah.
John, just go relax. All I want to say is that okay, that's exactly what I'm trying to say. I was trying to say let's table the corporate law, but I think it's good that we have to go to because since you mentioned corporate law so much, especially early on talking about the corporation,
Yeah,
I think it's good that we have a subsequent talk about corporate law later after we finish the Magna Carta. We should have
yeah,
a talk about it.
and there is mention of like an individual and a corporate entity infused into one, and how they act, how they're infused into one and in law actually. So, but yeah, I just wanted to go over like the history and the application of the Magna Carta first. Is that okay? Like,
No, yeah, of course. I'm just bringing up these things because
okay.
because because you
Oh, sorry, you're cutting out there. Hello, hello, hello. Shoot. Hello, hello. What's going on here? Hello? Hello? Are you there? Hello? You cut out there. Hello?
hello, can you hear me? Can you hear me?
Yeah, sorry, you cut out there.
I cut
I
out
didn't
there.
know if there was
Okay.
something wrong with my computer. I just stopped screen
It's
sharing
me.
there.
No, it's me.
Okay.
If I ever cut off, just keep going, okay? If I cut off, just
Okay.
keep
Okay.
going. Yeah. Don't worry about me. I cut off a lot. Okay. No,
Okay.
but hold on. Before you start, the one thing I wanted to say is since I'm here to question you, I got to question you on certain things when I see an issue, right? I'm here to
Uh-huh.
question you, but
Okay.
that's fine. But the reason is because it gives us something to do for later streams, because we do gotta get back and learn about this corporate law thing. You understand? Because
Okay. Yeah,
it
I
play.
will mention it later. Like there is actually a clause. But yeah, I don't want to just get sidetracked into
No,
corporate
we
law.
don't.
I wanted to try to keep it on topic.
Of course, of course,
Um, okay,
of course.
okay. So who are the 25 barons? These are people wanting reforms of taxation and the way justice is carried out. New barons are sworn in when one becomes deceased. This has been going on since the inception of the Magna Carta in 1215. So there is actually a barons committee today. I actually do have like one of the slides. I do have like a picture of like 25 barons in the background. Um, that they're still existing today, and you can also look them up as well. They also act as judicial officers when an oath is sworn by the citizens of the realm to avoid any fines that aren't justified in the nature of the offense in accordance with the Great Charter. So that's part of the oath there. So that's one of the privileges as well. So who is the Magna Carta binding upon? So it's binding upon any crown agent, which would be police officers, municipal workers, provincial or federal servants, and federal servants. So that would be like court workers, yeah, anything like that. Uh, Her Majesty Queen Elizabeth II, who is heir of King John. Letter of redress must be sent to Her Majesty at Buckingham Palace. She has 40 days to respond. So if you have if any wrongdoing has been done onto you, you can write a letter to Her Majesty herself, and she has 40 days to respond. After 40 days,
Okay,
you
okay, okay. In practical terms, about Her Majesty has 4 days to respond. Who actually writes the letter? Doesn't the Majesty get millions of letters a day? So how does how does Her Majesty know which letters are for what, and how does it bind her? Like how is the practical issues of giving her a letter of your grievances? How does that practically work in real life?
it has to be like a registered mail that you send to her, and so yeah, within a reasonable time. But usually it's in the law. It's 40 days, um, and after 40 days, if there has been no redress or within a reasonable amount of time, um, then you swore an oath to the 25 barons. You can make up a document. Basically, if you're part of a member of the corporation, you can put in the member of the corporation. If you're a private citizen, you can put in you're just a private citizen who has sworn an oath to the 25 barons, and that you're practicing lawful dissent with lawful excuse. And then there's also other privileges as well too that come with that. So yeah, so the 25 barons is basically you swore an oath to, and then yeah, like I said, like I just mentioned, the treaty can be invoked anyone that falls under the crown, so a citizen of the Commonwealth country. Any Parliament statute made does not override the common law and provisions of the 63 clauses of the treaty. So what are the clauses in the Magna Carta? The 63 clauses in the Magna Carta, in accordance with Clause 61, successfully invoked March 23rd, 2001, which I already mentioned. When one clause is invoked, all clauses are binding. The original document wasn't written down with separate clauses. They just what they did is they put it in different clauses, so it was more readable. Subject reserves the right of habeas corpus. So where a writ must be submitted to the court to arrest or detain upon reasonable remand. And also the right of counsel without delay. So basically, you need to have a jury of peers before the court, and also a writ of habeas corpus must be submitted to justify anyone's detainment. If anyone is being detained or arrested, the person must be submitted to the court with, and they can actually request. It's called ad sub. Habeas corpus ad subjectium. So you could basically ask for a request for a writ of habeas corpus to be submitted. So you just basically you can do this on. You can also like assign somebody as a power of attorney as well too. So if for whatever reason, if the crown is denying you a pen and paper for your habeas corpus to be written out on, or even a computer. I don't really want computer, but you can do this on like a pen and paper as well. And then so you do that, and then they're supposed to bring you before a court, and there's a physical copy is supposed to be submitted to you justifying your detainment.
Okay, yes, because in America we have the same law too. The writ of habeas corpus, they have to have a charge. That's even the base of the Miranda rights. Because when an officer arrests you, he has to read you some Miranda rights to give you your basic understanding of the accused in relation to his arrest. So yeah, we have this. He said, okay, did you get okay? So now you all right. So it's 2 more bullets to go. All right then, 2 more bullets. Because after we finish this page, I want to do a chat room break. So I will do a chat room break like every so often. I want to read the comments on the chat because if people are watching us, let's engage with our chat members too. All right, so let's finish this and then we do a chat. Then we do a chat room break and then we go back. All right.
Sure. So presumption of innocence before proven guilty. A trial must be held by a non-biased judge and before a jury of peers. Crown counsel must submit evidence to an open court. Any doubt of guilt remains, charges must be dropped. Also here, political offense exemption clause. So any personal information collected by any means of a political nature may not be used against you and or distributed to another state in the court of law. So this one's quite interesting because this one this would also apply to a private person as well. So even if a private person, but also if you're part of a political party as well. So let's say I'm like, maybe I'll provide an example for this. So I'm like a Crown prosecutor, right? And there's this federally registered party. It's called the Transgender Party. And I disagree with some of their platforms. And I want to, let's say, prosecute them. I'm trying to justify that they're a threat to the public with their platform, with the crime let's say they committed mischief, and suppose like there's always a presumption of innocence. I think that's kind of lost on our ethos today, a presumption of innocence. But there's that presumption of innocence. But I want to prove that they're guilty, right? And part of the evidence I want to use is I feel that they're a threat because they are they're using they're saying that they need to have they need to promote transgenderism to children, and I want to use that as evidence to prove that they are a threat to the public.
Yeah, because doesn't law or legislation have to be made that says they're a threat to the public? Crown prosecutor can go and prosecute them, doesn't have to be like a legislator, because who's to give the crown prosecutor what discretion to prosecute a party? Who gives them that discretion? What laws dictate their discretion to do so? Is there any set of laws that dictate their discretion to do so?
Only in no, like only in terms of like uh anything that might incite in Canada anyway. I know in America you're more free speech, but in terms of like hate speech laws in Canada, if it's a identifiable group, um, they would like if you're promoting violence to an identifiable group or seeking to invoke violence against an identifiable group, you could be charged under the Hate Speech Act. But if you say something, you still need to follow like legal procedures. So say like if okay, so I'll just use our party example. This is a real life example now. So the leader of our party got charged with actually hate speech, and it was supposedly at a identifiable group, even though there was no identifiable group cited. It was only projection and opinion when he referenced the parasitic tribe. I don't care what you people say in the chat. It's still your opinion, and you're entitled to your opinion. But in the court of law, it's not hard evidence. It's a statement of opinion. It's not a hard evidence of fact. Those are actual legal terms. So yeah, but it seems like we kind of live in a cloud world now, where opinion is fact now. But yeah. So that's basically. Does that make sense?
I mean, yes.
Mm-hmm.
It makes sense because we should have hard law. I mean,
Mm-hmm.
should have hard law. I understand where the opposition come from because even in America, the Jewish lobby, the ADL is strong, and they're strong about finding any type of concealed or open anti-Semitism, and
Mm-hmm.
be honest with you, I believe it's understandable because of what Jewish history has gone through in the last 100 years with the Holocaust and all that. So I totally see this understandable for a civil organization to try to find these things, but in the court, but in the court of law, yes, we should have hard law in a legal sense. So
Mm-hmm.
yeah, so 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 and that's
So
why it's good to.
even if somebody from the JDL, even if so, if somebody from the JDL is a crown prosecutor, let's just say, they can't use that information. So like, any they feel that any political information that might go against their agenda, like if there's no hard evidence that there's an actual incitement towards identifiable group, and if they're prosecuting someone based upon their own opinion, whether that be personal experience or anything like that, like you're exempt from that information being used uh, against you in the court of law. I mean, theoretically, in Canadian law, it's not specifically used, but in the Magna Carta, once you invoke it, for sure, they can't use any political offense. They can't use any political offense in the court of law against you to justify any detainment or any charge against you, right? Or yeah, you're a threat to the public.
Okay.
Yeah, yeah,
So that's the last bullet point in this one, right? That's that's
yeah.
that's
That's the
that's
last
that's last.
bullet point. Yeah.
Okay, wait. Okay, so yeah, and it's good because it's a good segue to the chat. Okay, this is a good segue to the chat. So I'm gonna
Okay.
do a chat. I'm gonna do a chat break. I'm gonna do a chat break.
Okay.
It's a good segue to the chat. Okay,
Okay.
again Tehran says salam to chat. Salam alaikum. Okay, so we have Claire, right? Claire is saying at least John isn't praying to Jesus anymore. Okay, that doesn't yeah, okay, yeah, John's a Muslim. Salam alaikum. We know that. Ramadan Mubarak. Okay, so the next question in the chat is, when is Travis undergoing his mental examination?
He's already gone through his mental examination. They are just waiting for the reports to be submitted. They should be submitted by May 14th. So he's already gone mental examination.
Okay, so is Travis the leader of your party? He's the leader of your party?
Yeah.
Okay. Okay then. Okay. So that's the leader of the Canadian Party. Okay. The next question is wait, the next question is
Was that it?
Yeah, I just think it's important that we engage with the audience because I want us to have an audience-driven show. Can you hear me?
Yeah, I can hear you.
Okay. So no, that's not it. That's not it. Hold on, Claire. I mean, I said Claire. Hold on, John. Okay, so Claire again said Claire again said okay. Claire again said yeah. So no, because I was answering Claire's question about what is the rights conferred by the Magna Carta that CMP claims. Well, the point of the show is to first learn about the Magna Carta first, and then we're gonna get into that more later. But that's the
Sorry, what was the question?
what is the rights? What is the right conferred by the Magna Carta that the CMP claims has been infringed by the Canadian government?
That'd be clause 1, the
Okay,
freedom
clause
of
one.
churches election. Yeah. I actually do mention that actually in another slide too, and I will
Okay,
get to that as well. Yeah.
we'll get it there. Okay,
Yeah.
okay.
Good,
So
good question. Yeah.
okay, that's a good question. All right,
Hmm.
so that's clause one about the churches, that's
And
what I
I
got.
could expound on that too. Like in later, I'll actually go through like a case that the CMP is claiming as well too. And in the case, they claim that the charter rights and freedoms are violated, but also the Magna Carta can be invoked as well too, when you feel justice has been delayed or denied to you as well. So I would say two clauses. The first one would be freedom from churches election. So the first clause, and clause 40, a right. No one has the right to sell, delay, or deny justice of anybody in the realm.
Is
So
sell is sell deny what?
to sell, deny, or delay justice.
Okay, delay justice. Okay, no, because
Yeah.
I'm taking notes. I'm actually taking notes. I'm actually taking notes as we go
Okay.
along. Hold on. Okay.
Okay.
So so now the next question is the next question. Hold on for a second. Hold on. I gotta do this because it's important for us to do. It's important for me. It's since I'm doing this with you that it be audience driven too. You understand? Because that's why I'm here. I'm here to question you on behalf of the audience too. You
Yeah,
understand?
I know I'm peppering a lot of information, so maybe I will. It's good
Yeah.
to have
Okay.
these
So,
breaks. So sure.
yep, it's good at this. Okay. So the next question is John aware that Allison Chobos is in prison for Holocaust now when it's not even a law against Holocaust now in the UK? That's also from Claire. If you know about Allison Chobos, you know.
uh, yeah. I think I've heard that name before. Um,
It's not
there's
important.
actually a Canadian that was actually in prison. I forget her name, but she was a member of the Green Party, and she was actually imprisoned in Germany for I guess questioning the numbers of the Holocaust of 6 million. She's skeptical that 6 million people of I guess ethnic Jewish background specifically died in the internment camps in World War II. And so
Okay,
she made videos of
so
this and facts. And she was in Germany at the time, and she
right?
was actually held in custody. And then
Oh
the
yeah,
Canadian government
'cause
dragged
Germany
its
has
feet.
strong. Yeah, because Germany naturally has strong Holocaust now laws. Germany has them
Mm-hmm,
strong because they don't have First Amendment. I mean, I mean, I
mm-hmm.
mean, I mean, I mean, I'm someone. I'm not a Holocaust now. I'm not. I want to make for the record, I'm not a Holocaust now, but I do think people need to have the ability to have free speech and question things.
Yeah,
Yeah. I
I
told you,
think
but
like
again, for
uh,
Holocaust now.
mhm. I think like even though Canada has hate speech laws, um, typically like those are like as long as you are preaching from the Bible. So if you're a Bible preacher and you're preaching about homosexuality, as long as you preach it from the Bible, there's actually some pretty strong verses in there as well about homosexuality in the Bible. So as long as it's straight from the Bible, or as long as it's factual to the best of your knowledge, and you're not if you're spouting opinion, you might get yourself into trouble in Canada. But as long as you are citing from the Bible, because it actually says in the constitutional law that this in the Supreme Court of Canada ruling that you can't have any the Supreme Court can't interpret Bible verses. They can't interpret text. Like they don't touch that at all. As long as it's straight from the Bible, and as long as it's a factual statement to the best of your knowledge, they can't really charge you with anything. But once you get into the realm of opinion or political speech, if it's an identifiable group, that's what I guess they would charge you for. So it has to be incitement towards, like, direct incitement, not projected on or somebody's opinion, but it has to be like a direct, I don't like these group of people. I think, this should be done to them, right? Like it has to be a direct statement, right? So yeah, that's when you might get in trouble with like hate speech laws in Canada. Anyway, I know it's maybe a little different flavor, but yeah.
Yeah. Okay then.
Mhm.
That could be a whole discussion later for ourselves too about the hate
Mhm.
speech law in Canada. Okay, that's good. Let me get to the next question. Is is John aware that a UK pastor Sherwood? That's good. It's a good segue. The UK pastor Sherwood spent the night in jail for saying that marriage is between a man and woman. Did you hear about that before?
Uh, yeah. Lots of UK viewers today. um, yeah, like in Canada anyway. I don't know what the UK, but in Canada, I know that you can't you can in some aspects, like if it's like a private church, that private church can deny services for same-sex marriage. But if it's like a public church, there is some laws uh, that you that you need that you have some sort of obligation towards marrying a same-sex couple. I might have to revisit that a little bit. I know I was reading that a little bit, and it gets a little bit complicated. But I know for sure, like if you're a private church, like you're not obligated to marry a same-sex couple. But when it's public, there is some instances where you're obliged to marry a same-sex couple because it infringes on their rights, right? So as a public, if you're a public institution, you're bound upon more of rights, as opposed to if you're private, you have a little bit more discretion. I know in that sense. But yeah.
Okay.
Mm-hmm.
Good. Let's get to a couple more. Let's get to a couple more. The next question is well, I get a lot of questions, but it's mostly clear. Mostly clear, just talking a lot. But okay, but next question is the next comment is a comment said the rule of law is breaking down all over the West because Christianity is kaput, and John is too afraid to tell Islamophobes that Christianity is kaput. I mean, you just not prayed al Fatiha to your best ability. So don't pay attention to
Okay.
too much.
Okay. Yeah, I've seen that comment before, and it's just like, yeah, I'm not going to go down that rabbit hole again. I've gone down that rabbit hole so many times with Claire, and I've told Christian friends about the Trinity is invalid. Because how can you have something? How could God create something that is finite, that is of His offspring, and all that? I've actually a member of the party stopped. Like he actually blocked me on Facebook over that. So I don't know what she's talking about. Does she want me just to condemn all Christians? I don't even know. Like it's just such a innocuous statement. Like, yeah, that's like she's said that so many times. I don't even know where she's coming from. That's not necessarily a good faith question. So I think I'm going to move on.
Yes, of course. You can move on. Hold on. I'm asking you the question. Let me be the one, because I'm interviewing you. I'm questioning you. I'm questioning you today. So the
Okay.
the next question is oh, this comment. Even if you had a proper cause of action, the co-opted courts will ignore you anyway because they did this to Trump. So what makes you think they are going to listen to the political pariah CNP? So they call a party a pariah, and you said the courts are going to. But see, but that's in America. That's two different countries. First of all, two different countries, and it's two
Uh-huh.
different things. It's two
Uh-huh.
different legal codes. But she said
Yeah.
again, I'm reading one more time. Even if you had a proper cause of action, the co-opted courts would ignore you anyway because they did this to Trump. So that makes so what makes you think they are going to listen to the political pariah CNP?
This is if there's no judges out there that are keepers of the faith, this will ultimately be appealed to the ultimate judge, Jehovah. There's actually a page where we actually make a trial by faith. And so this is why I did a prayer before we did this today, because this is ultimately going to making the case before God. So this is trial by faith. And, there could be a judge that honors the faith and actually addresses the argument. Or there could be people like in the end times, the Bible does say that the Pharisees will break the law, break their own law to accuse you of breaking the law, and you see that all across the West today, where you see people interrupting church services, especially in Canada, breaking their laws. There's actually a law in the books that says you can't interrupt a church service. And then writing people tickets. So in that sense, somebody can actually write a letter to the Queen seeking redress as well too, because that's clause 1 is being broken on that treaty. But yeah, all the crown agents, they know that this is binding, and you just have to have faith that like not all agents are bad. Like I'm not saying like all government agents are bad. I know, especially now, there is that reputation that there's a lot of corruption in high ranks, and I totally get that. But there's also there's division between those people. So you just have to do it by faith. Like you're making a case before somebody who absolutely despises you and just going to ignore you, or you're going to make it to somebody who actually takes these clauses seriously. And you have to make sure that you're knowledgeable and you know how to assert your own rights. So that's just it's just by faith. It's I don't know what else I could tell you, but yeah, it's just by faith. I know Claire doesn't get that because she's an atheist, but yeah, it literally is like it's just like you know what I mean?
Yeah, John. Yeah, John,
Mm-hmm.
can you hear me?
Yeah, I can hear you.
Oh,
Yeah.
I was gonna say, John, and that's one thing I admire about you, that you decided to walk by faith, and that's a good thing in life. I mean, we need more people like you going to walk by faith, because that's the only thing that's going to heal people and remedy the situations that people are facing in the individual lives, and that people are facing as a collective. Why I say individual collective? Because the collective is made up of individuals. So individuals like you have to get with more individuals like you and move the collective forward by individual action and by individual faith. And everybody has to reconcile themselves to the reality of the world, the ultimate reality of the world being God Almighty. So that's something I really do appreciate about you, John. Yeah, I really appreciate that.
Yeah. It's better when you come to those rational conclusions that basically it's just you have to walk by faith. That's probably the most beautiful thing. Like some people have blind faith, I guess, and that's fine too. But at the same time, that can be destructive. But when God leads you to rational faith, that's an even more beautiful thing. So
it definitely is. It definitely is.
Mm-hmm.
And
You're just like, I don't know what else I could do now at this point. I'm just like, I guess I have to appeal to a higher authority, which is, the creator itself. Yeah.
yeah, you're right,
Mm-hmm.
and you and like and remember I see you like the conversation that Toronto and the Shake had yesterday, right? Remember
Mm-hmm.
Toronto? It was a good conversation, right?
Mm-hmm. I did
You
see
know what I'm
parts of
talking
that.
about?
Yeah. Mm-hmm.
You seen parts of it. You didn't see the whole thing.
Actually, I probably saw the whole thing. I lied. I probably see most of it. Yeah, I saw most of
Yeah,
it.
but it was good,
Yeah.
right?
Yeah. Yeah.
Okay,
That was
okay.
interesting.
Wait, hold on.
But
Let me.
yeah, sorry, I don't want to get divulged into that. But yeah. So, any other questions?
Yeah, yeah. It's a lot of questions. Hold on.
Oh,
Um.
jeez. Okay, if they're not good faith questions, then I'm not going to answer them. I'm just going to continue.
Oh, okay, okay. I know, because this series. Because the thing about it though, I want to maximize our thing because we don't got to finish the series in one day. We could go back to it like in a couple of days because I mean I want everybody to fully know the issue perfectly. You understand?
Okay.
So we don't have to rush and get through your whole presentation in one sitting. Whatever we don't get done, we get another sitting. We can even get three sittings. I'll keep going because I just want to since we're small, it's good to interact. It's good to interact. You know what I'm saying? Because we're small.
Okay.
Okay, so the next question is the next question is um okay. Search. Wait, hold on. Wait, that's a lot of questions. Okay. So about the thing, the rule of law is breaking down. Okay, okay. Claire said the Canadian authorities are going to declare Travis patient of unsound mind. Do you think that's going to happen? You think that's going to happen? That Travis will be declared unsound mind?
There is. Uh, yeah, that's just basically like I view that as like it's a court procedure in Canadian law where if somebody is viewed as a public threat, so if they have like multiple offenses, they submit them to psychiatric evaluation. And actually, that's the story I did. I did a video on this on Friday, and they basically like he told the psychiatric officer that he committed no crime and that he wants a writ of habeas corpus submitted, and that the psychiatric officer said, "Well, we can't deal with if you want an application of writ of habeas corpus, it'll have to be to a higher court." So it's kind of yeah. There's no as long as you that's kind of I guess you can go into that a little bit, but
No. There's no need to go.
okay, yeah. I mean, basically, what it is it's you're not okay. So basically, what it is, I just said this before, in that just because you go to a psychiatric evaluation doesn't mean you have an unsound mind or your presumption of guilt, and that doesn't necessarily mean that you can't defend yourself in the court of law. It's just a procedure. Like if a judge sees you as a threat,
The comment was Claire was saying she was making an assertion that the court is going to declare Travis of unsound mind. So what do you
okay, so that's an assertion. Okay, that's an opinion. Okay, yeah, then I'm not necessarily going to address that, but I'm just going to address the cases right now. I'm going to say this again. A psychiatric evaluation doesn't insinuate any guilt or any person that is unsound to defend themselves in the court of law. Yeah, and if even if the media says that he wants a writ of habeas corpus sent, and I think that's a very sound legal mind. So I don't know what they would get him on, but yeah. That's an assertion. No results have come in, but I'll say it again. That just because you're in a psychiatric evaluation doesn't necessarily mean that you are unsound to defend yourself or you're found guilty of something, in a court of law. So in that sense, it's like, okay, whatever, like, yeah, it doesn't insinuate anything yet, or there's nothing that would prohibit him from exercising his rights. So, that's just the process. So yeah. Anything else? Hello? Shit.
Hello.
Oh, okay. Sorry, I lost you for a second.
No, it's okay. It's okay. Don't worry if you lose me. Don't worry.
Yeah,
I'm here.
yeah. Just try to stay away from assertions. Okay. I think I'm going to. Is there any actually good questions on there, or just like Claire just shit talking again?
Don't worry about it. Don't worry about it, John. This. I mean, we have.
Okay, I'm gonna keep going then.
Yeah. No, wait.
Okay,
Hold on.
if
Wait.
it's just Claire just shit talking, and I'm not gonna address it.
Okay. No. I'm not gonna address Claire. Okay. I'm not gonna address Claire. Is craziness. I'm not gonna do it. Okay. I'm not.
If she's making a lot of crazy, like if she's spamming with like a lot of assertions or insults or anything like that, just let me know and I can get rid of her.
No, it's okay. It's okay. No, but some of them were, but now see, no, wait, because some of them were good. Well, yeah, some of them. Okay. I'm gonna give example. Let me see. This is an assertion, but it's actually a constructive thing to talk about. Claire said, "I bet you won't find a single lawyer prepared to pursue the case, even if you can afford the fee." So, what is the legal situation now? Do you have a lawyer?
Okay, I'll get to that. I'll get to that. There's actually, I have a case. I have everything. I did the whole presentation. So, if there's no other questions, I will get to that. There's actually a case law I'm actually gonna pull up here after I'm done doing this. But yeah, if there's no other questions, I think we'll move on.
Okay, let's move on then. Okay, let's move
on.
That's fine.
Okay, so how is the Magna Carta invoked? So when 63 clauses have been, any of the 63 clauses have been broken, Her Majesty, heirs, or crown agents, redress must be submitted, stating your case. Ignorance of the common law is no excuse. They will still be held for high treason for not honoring the treaty when called upon. If 40 days have passed, so I mentioned this earlier, and redress hasn't been made by Her Majesty, the subject can practice lawful dissent in accordance with Clause 61. Subject can distress the Crown in any way possible, seizing public assets that are owned by the Crown, such as libraries, city hall, provincial, national parks, etc., until redress has been made. So basically, when a contract has been broken, if you have taxation without representation, the treaty is the Great Charter. I keep calling it a treaty. Charter is there so that you can gain redress in this life. That's basically the purpose behind the charter. Because I know it's based out of it's a Christian doctrine. So it was like like the Christian doctrine is just like in the afterlife you will gain many rewards, but this charter was kind of inspired by that Christian ethos, and it was basically like, well, how are you going to get redress in this life, right? So this is basically how the Magna Carta was inspired as well too. It was off that Christian ethos as well. So yeah, keep going there. It's a cool graphic. So if you're practicing lawful dissent, how will they know, right? So serve them a notice that you're practicing lawful dissent. So either stating your organization, name, and title if applicable. So if you have a title of a corporation, so I'm a member in good standing of the Canadian Nationalist Party. So you can serve them a certificate here saying you're a good standard, or you can serve them like as a private citizen as well too. And then that you so that they know the status uh, of of your uh, of your legal status with the crown. That's just to let the crown know your legal status, right? Um, also, state specific claims that are relevant to the circumstance, such as writ of habeas corpus, to avoid arbitrary, unlawful detainment or arrest. So yeah, if somebody is trying to detain you or arrest you, you need to ask them. A good thing would be so if an officer is threatening to arrest you if you're walking the streets past 8 o'clock, and is like, well, what justification do you have to arrest me? I want a writ of habeas corpus submitted before the court before you arrest me, right? So you could say something like that, right? That would be like a good interaction, like a thing to use, right? Um, yeah. So I mentioned before, you swore an oath to 25 barons. So when you swear an oath to 25 barons, any unlawful fine must be remitted or judged by the committee. So anything that is non enforceable. There is fines like such as like speeding that is binding upon law. So like I said earlier, it just because you swear an oath to 25 barons doesn't necessarily mean that you're above the law. This is for redress purposes. So if you have a speeding ticket, you can still serve a notice for sure, even if you're having a speeding ticket. It's just that that those any laws that are with public consent is still binding upon you. So like any speeding laws, any bylaws, anything like that, you're still bound upon it. But if any of those laws might, break your rights or anything like that, like or anything that's not of public consent, you can, and you're getting a fine for it. You can let them know that you've sworn an oath to 25 barons, and they must remit the fine. Usually, most of the time, because most of the time, what they'll do is if it's like a constitutional challenge, like in the courts, like if this law breaks my constitutional rights, so like the right to the freedom of religion, right? Most of the time, if it's a constitutional challenge, like a law that is pretty flimsy to begin with, the courts will throw it out right away, or they might like backdate it. That's like most of the times it happens if it's a constitutional violation. So, our system does work. And anything too, I was actually reading, the courts don't take anything the government writes down in face value as well. There needs to be evidence that support it. There needs to be justification for the limit of the constitutional rights being limited or being restricted. And if there's no other policy that is less limiting, then it's not binding upon. It's not enforceable in the courts. So the cop can write you, so many tickets, so many COVID tickets or whatever, I guess you could say, but it doesn't necessarily mean that it's enforceable by law. Yeah, and it's starting to get a little bit dicey in Alberta. I guess they want to if you get fined and if you don't take it seriously, your driver's license will be revoked. I guess the way I interpret that, Jason Kenney just came out with a policy where if you get like a COVID fine and if you don't take it seriously, I'm guessing like if you don't like take it to court or something like that, if you don't show up to court or something like that, your driver's license could be revoked. So always make sure that you show up to court and or have the intent to show up to court, and always call the day before as well too, especially if you live in Canada. I don't know what the states are, but yeah, just to confirm your court date, because they might have it like they might move it to another day, or they might have it say, oh, we're just rescheduling on the phone kind of thing. So yeah, always call the day before your scheduled court date just to confirm. It's always a good rule. Also to act with honor, respect, and dignity. So so basically don't swear at the Crown employees. Try to be as respectful as possible when you're interacting with any Crown employees. So it'd be like police officers, clerks, anything like that, judicial officers. you're not outside the law when it comes to keeping the peace. You can't act outside the clauses or use them to disregard any court proceeding rules. These are used to gain redress when all avenues of justice have been exhausted. Right, cut out there in the end. So these are some more common law rights.
Oh, okay, though.
Okay. Yeah.
Before we get to common law rights, let me ask you a couple questions from the chat. A couple.
Okay.
Not that many, just a couple. Okay. Because
from Clarion?
No, not from Clarion. They're from a new person. They're from Spiritual Mamzer. If from Conops.
Okay.
From Conops.
Oh, geez.
Okay. Conops asks, how is Travis patron? Does violently beating up two women also constitute the right of?
Okay. Just okay. I'm gonna. Okay.
You gonna know that one?
Yeah. I know him. Hang on.
You gonna know Conops?
I think Spiritual Mamzer is going to get a boot here.
You're gonna get it? No, don't boot him. Don't boot him.
No. Where does it say it?
He has one question. I mean, if he didn't do it,
That's not a good faith question. Sorry.
Okay then. Is your channel?
Okay, I will delete the comment. Hang on.
Yeah, just delete that one comment.
I'm gonna put you in timeout. Actually,
don't ban.
You learn your lesson. I put him in timeout.
No, but I want to see his question though. He has some more questions I want to see. All right then.
I put him in timeout.
Oh man. Okay.
I'm not a whore. I'm not a whore to. Yeah. I am a public servant, but I have. There needs to be good faith questions in the chat. I know in the internet, people like drama and stuff like that. So not gonna bother. But any other good questions though? Like just don't But thank you for letting me know. I put him in timeout. Maybe you've learned his lesson, but anyway, any other questions? Okay, I'll move on then. It's my stream, so I'll dictate the rules here. All right. Exclusionary rule, which prevents evidence being collected or analyzed in violation of the accused's constitutional rights. So that's basically the political offense exemption rule. This also extends to your constitutional rights as well too. So anything, any evidence that violates your constitutional rights can't be used, like freedom of assembly, stuff like that, freedom of religion, freedom of assembly. Right to fair trial. Subject of the realm has a right to a fair trial within a reasonable time. Right to remain silent. The accused retains the right to avoid self-incrimination, including provision that adverse inferences cannot be made by judge or jury. The refusal of a defendant to answer questions before or during a trial hearing or any other legal proceeding. So negative inferences can't be made to anybody who exercises the right to remain silent. That includes the judge and the jury, basically. Does that make sense? Hello?
Here. Hey, say it one more time. Say it one more time.
Okay, so you have the right to remain silent. The accused retains the right to avoid self-incrimination, including provision that adverse inferences cannot be made by a judge or jury regarding the refusal of a defendant to answer questions before or during a trial, hearing, or any other legal proceeding.
Okay, that makes sense. I mean, that's almost the same thing we have in America. It's the same type of laws.
Yeah. Okay. Yeah. That's what I'm saying. It's kind of infused, so that's why it's kind of fused together. I'm there's some redress, that is specific for the Magna Carta, but there's some that is infused with what we have today. So yeah, that's kind of the nature of the presentation today. So yeah. I actually do have a clause here that's specifically from the Magna Carta. So first, that we have granted to God, and by this present charter have confirmed for us and our heirs in perpetuity, that the English Church shall be free, and shall have its rights undiminished, and its liberties unimpaired. That we wish this to be observed appears from the fact that our own free will, before the outbreak of the present dispute between us and our barons, we granted and confirmed by charter the freedom of churches' elections, a right reckoned to be of the greatest necessity and importance to it, and caused this to be confirmed by Pope Innocent III. This freedom we shall observe ourselves, and desire to be observed in good faith by our heirs in perpetuity. To all free men of our kingdom, we have also granted for us and our heirs forever all the liberties written below, to have and to keep for them and their heirs, of us and our heirs. So basically, anyone of royal assent, or of anybody who represents the crown, this is to be observed and unimpeded at all cost.
Hey, stop, John. Okay, if you look at the last part, right?
Yeah.
To all free men, what isn't the laws? Isn't the laws the action going to be after this part? Because it says written out below. So that means this clause in the bottom, or this paragraph in the bottom, refers to the next part of the charter. Um, wouldn't that make sense by saying written out below?
Uh, yeah. This all the because it mentions on the first part. It just mentions the barons, but any barons or royalty need to observe this, the freedom of churches' elections. So it's binding upon them to keep the faith. If they don't keep the faith,
No,
all
no.
free men of the kingdom can seek redress. And then
Yeah,
basically, this
listen,
also influences any of the men, any free men. So not just barons
I
or
know,
the royalty, but any
but
free
it's
men of the
telling you about
kingdom.
the laws later. But look, why does it say? Because look, okay, I'm reading it in. See, look, it's it lays out laws. It lays out laws for free men, but the free men is tell you what the laws are. Like the first law is if any earl, baron, or other person that holds lands directly of the crown for military service shall die, and at his death his heir shall be of full age.
Sorry, you cut out there. Hello? Oh yeah, so he's just going through all the clauses. Yeah, so the clauses. I don't know if you can hear me or not, but all the clauses, they are subject to interpretation without impeding the necessity, or the original intent of the clauses. This one's very important, uh, in that it's to be unimpeded any way or possible. Other clauses tend to be subject to modern interpretation. Especially there's one clause that talks about like scutage. Um, but yeah, that could be another stream. That's why I really didn't want to be like going through the Magna Carta, and like, because it's translated from Latin to English, so it'll be a little bit tricky to kind of decipher some of the clauses. But there is some clauses like Clause 1, Clause 40, and Clause 61. They're very clear and very concise, that will be used, and that's why I have focused the presentation on infusing how the Magna Carta, not only mentioning specific redresses or specific clauses, clear clauses, not those other clauses, but clear clauses that are to be unimpeded, um, and how they infuse into law, and how to gain redress from that.
Okay.
Yeah, so basically, like some of the clauses, like it is tricky. That's why I say too, it was written in Latin originally, and then it was translated into English, and it's also some of it's Old English as well. So it's a little bit tricky, and even lawyers will tell you this too. it's some of it is kind of hard to enforce. Especially it talks about
Look,
Jews in there.
look, hey, stop. Yeah, of course, right? But look,
Uh-huh.
but you,
Yeah.
you understand. You understand. The first clause is different than to all. See, from one time, from the first clause you have is different. It's about God and the church. But then to
Uh-huh.
all free men, okay. The next 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Okay. So see, clause 1 is for the church, right? But in clause 2,
It's
all the
for
way.
the barons and the royalty as well to observe that the okay. So we've granted from God by this present charter we have confirmed for us and our heirs of perpetuity.
To
That's
61.
royalty. That's royalty, right? So it's like the queen, heirs of perpetuity. So it'd be like Queen Elizabeth II, heir of King John. That the English Church shall be free and shall have its rights undiminished and its liberties unimpaired. That we wish this so to be observed appears from the fact that our own free will, before the outbreak of the present dispute between us and our barons, we granted and confirmed by this charter, uh, the freedom of the church's elections, a right to be reckoned with, the greatest necessity important to it, and caused this to be confirmed by Pope Innocent III. This freedom we shall observe ourselves. Keyword ourselves, and desire to be observed in good faith by our heirs in perpetuity. So the heirs of perpetuity would be like King
Look,
John, royalty.
but John, this first clause
Yeah,
you're talking about is first that we grant to God. So this first clause is about the church. It's not about individual citizens.
it's for the heirs of perpetuity to observe in good
No,
faith.
it's about how they observe the church. It's about the English church.
Right, and it's supposed to be. This is yeah. So the English Church shall be free and liberties unimpaired. That yeah. So it talks about the barons as well.
Okay, John. Okay,
Oh
I'm
my
reading.
god.
I'm gonna read it.
Okay, I think yeah, this is so it's this is not just the church. It's this is uh and then at the end here to all free men of our kingdom. That's why it's emboldened to all free men of our kingdom. So that also includes all the citizens as well, not just the church. And that so this also implies also the religious freedoms of the of
Hey, no,
I mean, it's
John.
enshrined. It's basically like illegal to interrupt a church service, right? So this is basically that was inspired by this first clause right here.
John. I'm reading it right now with you, right?
Uh
There's two
huh.
parts to the Magna Carta. The first
It
clause
says
by
here to
itself.
all free men we have also granted for us and our heirs forever. So this
I
also
know,
ties in here as
John.
well. So
There's more to it than that.
it ties into that first paragraph too.
It doesn't. John, listen to me, please. I beg you. I'm having a good faith argument with you. Look, the reason why I'm saying this, right?
Uh huh.
Because you have that, but I'm reading the whole thing. After that
Yeah, that's what I'm
is
saying. I'm reading the whole thing too, and I tie that into that last part. Yeah, yeah.
no, because no, but see, look, the first clause is for one set, and then the second clause, then from clause 2 to 61 is for a whole other set. Like clause 1 deals with a topic of a different nature than clause 2 to 61.
I think you're misinterpreting it
I don't know,
because
John. I don't
yeah, you're
know. I don't
misinterpreting it.
know.
Yeah, you're misinterpreting it.
I don't know, John.
Yeah, because it says to all free men of our kingdom we have also granted for us and our heirs forever all the liberties written below to have and to keep
No.
from them. And also
Is
so
that because
it's also granted. So also granted. So we also to all free men of the kingdom also granted these rights as well
no, John? It's
and
talking
our
about the
heirs.
next part.
Yes.
Yes.
and all the liberties written below.
Written
So
below.
this and all the so they also included this as well because they knew this was exclusionary of the citizens.
They didn't look.
Oh my God.
I'm reading exact words. To all free men of our kingdom, we have also granted for us
Mm-hmm.
and our heirs forever all the liberties written out below. To all free men of our kingdom, we have also granted what? See, we've also granted. So that means to all free. So before it was not through
We
all
have
free
also
men.
granted for us and our heirs.
Yes, listen, for us and our heirs. Before it wasn't for all free men. The first clause deals with the church. Then the clause 2 to 61 deals with what? All free men of our kingdom. We have granted all we have also granted for us and our heirs forever all liberties written out below to have and to keep for them and the heirs um of us and for them and their heirs of us and our heirs. So of us and our heirs means the kingdom. The us and our heirs is a plural, right? But he's talking about the king because the king talks about himself in the third person. They say we, even though it's one person, right? So I'm reading it clearly. To all free men of our kingdom is not about that first clause. It's about clause 2 to 61. That's why it's written
No,
below.
it's not. Yeah, no, that I'm going to disagree with you on that because it's also mentioning all liberties below. It doesn't. It's not exclusionary. It's actually inclusionary. That's an inclusionary statement of clause 1. The statement
I
of to
don't
all
believe
free men of our kingdom.
I don't believe that, John. I don't believe
Yeah.
that. I mean,
No.
I mean, we're gonna have to have a Canadian constitutional legal expert decide between us. I don't believe that, John. I think you're getting that part wrong. I do think you're getting it wrong. I swear to God, I'm not saying this to say this in good
Uh-huh.
faith. I do think you're getting that part wrong. I do think you're misunderstanding what to all free men of our kingdom means because that right there starts a new set of clauses. The first clause is separate. The
It's
first
still
is
that's still part of the first clause, though.
I don't believe it is. I don't believe it's part of the first
It is.
clause.
It is. It is. Like if
It's
you
not part of.
actually read it, go through it again. It's actually part of the first
I'm
clause.
reading the whole thing.
It is
It's
part of
separate
the
from the
first
first
clause.
clause.
Yeah, it is.
It's
It's
not
not. It's
part
not a
of the
separate
first clause.
statement. It's part of the first clause. It's the next
I think
paragraph.
it is a separate statement. I think it's a
Yeah.
separate statement
It's not a separate
because
statement. It's part of the first clause.
first of all, there's no real clauses because no real sentences have existed.
That's true.
All
I mean, this was
all the clauses were
yeah, this was written without any clauses. That's true.
I know.
Uh, and so this is
you have to
so
actually listen to me.
this is for readability, right? And this
John,
is why
John,
they
John.
put this
You have to,
together.
I know.
Uh-huh.
But John, I'm just letting you know. I'm swear to God, John. I'm not saying this to say this. I'm being 100% honest with you. If you look
Uh-huh.
at it, it's only exactly how you said. It's written in clauses for readability. That's not naturally part of the document. But if you look
Uh-huh.
at the document, if you look at where the sentence comes in, it's trying. It particularly tells you that it's talking about everything else later. So everything that happens in clause 1, even though that first clause is not really a clause, it's written for readability. That before to all free men of our kingdoms, that's one section. That's one section. First, they talk about the king, John, by the grace of God, and now before God. So see, the first
Well,
set
you
is
can
about
say
God.
to all free men of our kingdom we have also granted. So that is an inclusionary
No,
statement of the
it's
first
not.
paragraph. That's how I interpret that as well.
Okay, it's a document that includes the whole kingdom. Yes, it's including
Uh-huh.
the kingdom, but it's different sections of the kingdom. It's different estates in the kingdom that they're including, John. There's different estates in the kingdom they're including. And
Oh
the
yeah,
separate,
yeah. Because yeah, obviously there's a majesty and there's crown. Yeah,
yes.
there's definitely
They're
there's
including different
difference,
estates.
right? And you have to address that, right? And
Yes.
also the freedom of religion, and also that's addressed as well too. So that's why it's addressed, and that's why I said it was confirmed by Pope Innocent III. What I think what we're disagreeing with is that uh, you think that to all free men of our kingdom we have also granted. You think that's an exclusionary statement of the first paragraph, where I'm saying it's an inclusionary statement of the first paragraph. Because I see that as an inclusionary statement of the first paragraph. You see that as an exclusionary statement.
No,
I don't see it
hey,
that way whatsoever.
can you hear me? Can you hear me?
Yes,
Okay,
because
I see.
this is basically saying that you
Hold on,
you
relax,
have the
relax,
responsibility to
John,
uphold these rights,
John,
and
John,
that
John,
includes not
John.
violating
Hey,
the all
John,
free men of the kingdom.
John, can you hear me?
Yeah, I could hear you.
Okay, please, let me state my case, John. Please, I beg you, I
Okay.
beg you. I swear,
Okay.
I
Okay.
swear to God Almighty in Ramadan, this is a good faith thing. I'm telling you, I'm not telling you just to.
No, I understand what you're saying. I understand your argument. Yeah, go ahead.
So what I'm saying, John, is that it is an inclusionary statement, but is including the different states of the realm. Is it?
Right.
And it's not dealing. The first set of clauses, the first part of it deals with the crown and the church. Then
Absolutely.
after that, they're including in the document the all free men of our kingdom. So it's including the third estate of the realm. So it's including the states of the realm, but the states of the realm remain separated in the document as a whole. And then from to all free men of our kingdom, it is then is from that part when it's written about the liberties down below. That's when it delineates the liberties for all free men. But before that, it does not delineate the liberties for all free men. It deals with the crown.
I say because this is supposed to be observed by because you have to look at it as like everything is kind of fused together. That's why I made the presentation like this today, because I infused like common law rights that normal citizens have and that they should know and they should exercise. As well, I also put in redress here too. This is one of the redresses. So basically, like you have a contract between Her Majesty and you have a contract that there are specific clauses that Her Majesty, the Crown employees, or I guess, and there's actually barons too, that are supposed to follow. And if that contract is broken in any way, like taxation without representation. So let's just say, I'll go for an easy example: federal party being excluded from a public facility. Well, that's a break in contract. That's the heirs of perpetuity not granting the freedom of church's election to all free men of our kingdom. The, these are not just for the barons or the
First one's a
royalty.
Okay, look.
But it's supposed to be the reason for this is that it's supposed to be not just for the barons and the king, but it's also for all free men of our kingdom. I think that's a very important statement.
Not the point.
That's a very important clause.
Okay, I have to say I totally disagree.
You're saying it's exclusionary, but I don't see it as that. It's delineating different responsibilities to different levels of, I guess you could say, the constitutional monarchy nowadays. I guess you could say, or the monarchy. Because I know it's a little bit different in the United States, but here it's like there's different levels. There's actually it's an actual constitutional monarchy. Yeah,
John. I'm not saying it's exclusionary. You putting words in my mouth. I told you it's not exclusionary. I was not. I'm being clear. Let me be clear. I'm not saying it's exclusionary. I'm saying it's including different realms of the state. It's including, but it's it is an inclusionary separation. It includes the separate realms of the I'm saying the separate estates of the realm. But it is not confused. It is not blur. It does not blur the realm. It does not blur the states of the realm. It does not blur the states of the realm. It's putting all the states of the realm together in one document, is addressing all the states of the realm, but all the states of the realm remain separate in the composition of this document. That's the point I'm making.
Also granted. So also, yeah, I don't. Yeah, I believe this is binding upon everybody to observe freedom of church election.
It is, but
the thing is, like you have more responsibility, so they're putting more responsibility on Her Majesty and the barons to follow these this clause or these clauses.
it separates the states of the realm. So you have to understand which clause relates to which estate of the realm. And I'm saying from the part where it says to all free men of our kingdom, we have also granted for us and our heirs forever all the liberties written below to have and to
So
keep for them
also,
of us and our heirs. So it's a relationship. It's telling the free men of their relationship with the crown because of us and our heirs is referring to the crown. So the crown in person of King John is telling all the free men of the kingdom the rights that they have, the rights granted to the liberties granted to them, and it starts from clause 2. If an earl, baron, or other person that holds lands directly of the crown for military shall die, and at his death his heir shall be of full age and or relief to or a relief, the heirs shall have his inheritance on payment of the ancient scale of relief. That is to say, the heir of heirs of an earl shall pay £100 for the entire earl's barony. The heir or heirs of a knight's lieu at most for the entire knight's fee, and any man that owes less shall pay less in accordance with the ancient usage of fees. So and that's the first thing, and then it keeps going about different rights that all free men have. But it's separating. It's clearly separating. It's clearly first addressing the rights of what the nobility. Then it goes to what, to God, and that's the church. Then it deals with the church. So it first deals with the nobility and names out the nobility, and then names out the church. Because see, first starts with the king at first, right? Is a decree by King John of England in 1215 A.D. John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy and Aquitaine, and Count of Anjou, to his what? The first thing that goes to the church, to his archbishops, bishops, abbots, earls, barons, justices, foresters, sheriffs, stewards, servants, and to all his officials and loyal subjects, greetings. So it's going to the government because at that time the church and state are together. So the church and state are all part of the government because that's what the justices, the foresters, sheriffs. So the church and things are all together. The whole
right.
civil,
There's a contract. That's basically
right?
insinuating there's a contract between the crown and all free men of the kingdom.
That's when it starts. Yes, this whole thing is a contract. Yes, this whole
Yes.
thing is a contract.
Yes.
But it's separating the different. It's separate. It treats the different aspects or different components. It has different components, and it's treating components differently. So I'm trying to tell you that from the time it says to all free men of our kingdom is
We've also granted. That's inclusionary. Yes.
The following clauses of what is being referred to when it says to all free men is the following clause. It's not the beginning. The beginning is dealing with what the church. That's why it goes now before God. For the health, it's dealing with church and the civil administration. They're all together because it's also talking about the barons, justices. That's the courts, right? The barons, justices, foresters, sheriffs, stewards, and servants, right? And all the loyal and all of his officers and loyal subjects. Greeting.
And that's a contract between all free men of the kingdom and the barons and the heirs of perpetuity. That's basically that's a binding contract because it also says also granted.
I know you got to know the sections, though. You got to know the sections, John. You got to know the sections.
I think we're getting into semantics. I don't think this is really a fruitful avenue that's going down right now. It's basically a contract. It's a contract. If they break that contract, if they don't observe it in good faith, it's all free men of the kingdom. It's also
but you have to know the details in and out of the contract, John.
I don't know. This is getting to kind of into semantics now, and just kind of like it's not. I don't know. It just seems like you're exclusionary. It doesn't.
It's not semantics. You have to understand the law. You have to read the law carefully.
Like the thing is like it's just like like they're supposed to observe it, and that applies. You're supposed to observe it. You're supposed to be keepers of the faith, right? And obviously, there's going to be different competence levels. There's going to be a hierarchy, and there's going to be a contract that between it. So it's not like the thing is. I think your issue is. I think you read the clauses and you take them quite literally. And when you read the Magna Carta, you have to realize that it's infused with a lot of like other common law as well too, and that's why I made the presentation today of
I
asserting
know
your rights.
you're making
And
a presentation, but I told you I'm here to
like, the thing
examine
is,
you.
like, I think you're taking it to literally to a point where you're thinking that there's only rights for churches and
I'm
barons
not taking it to that point.
that they
I'm
only
detailing
observe.
the
But
different sets
it
of
says to
rights.
all free men in the kingdom, right? We
That's
have
not.
also granted
But
and their heirs.
you
Yeah.
not understand the whole document. You have to break down the whole document.
The whole document. So the whole document was written in Latin, translated into Old English. So it's subject to modern interpretation. And even
But
like any
still,
lawyer will tell you that this document, some of the clauses are not binding in like in the modern law today. But that one is very specific, and it actually says the rights to be unimpeded. It very explicitly says that.
thank God. You
Yeah,
have to
it
see the
explicitly
document.
says that. Like the heirs of perpetuity, like
You
they're not
not
supposed to
understand the
impede on any of the
document.
rights of any of
You have,
the
you have to look at the whole
subjects of the
document to
kingdom.
break it down. You have to
Yeah.
look at the whole document to break it
Oi,
down. And
oi, 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 oi.
you have to. I'm just telling you the truth.
No,
I'm saying
yeah, the thing is, you that's the thing, is you read the document and you don't realize the context behind it. You're just reading it and you're literally taking it down. I'm saying to you right now is that there's some clauses that are that specific clause says that the rights to be unimpeded, so that it is supposed to be observed in good faith by our heirs and our perpetuity and by the barons, right? And there's a contract between all free men. What I'm saying is those other clauses, like I said earlier, those other clauses are some of them are subject to interpretation because it was written in Latin and then translated into Old English. And
the
if you
whole
were to
thing's
talk to any
in
lawyer
that.
today, like even Ezra Levant says that those clauses, some of the clauses are not binding just because they're out of date, right? Like you can't really scootage. What's scootage, right? No, but it's still binding. It's just not really applicable, I guess you could say, in
I
today's
mean,
age.
what's applicable? I mean,
Like when it
it's
talks
almost like
about
you want to.
like
It's like this.
owning
It's
debt
like
to
this. Are
Jews,
you
like
trying to
something
read
like
something into
that.
the law, or are you trying to read
You
out of
know
the
what I
law?
mean?
No, listen, John. It's two
Uh-huh.
issues. I'm gonna tell you my issue with what you're saying right now.
Okay.
You can't try to read into the law. You have to read out of the law. You have to look at the law.
I'm telling you, this is how it's actually this is how it's taught in law school. You just read the document and you're just taking it literally. I'm telling you, you can't take the whole document literally.
I mean,
But
what you mean?
there is specific clauses, like the first clause, right?
Yeah. Legal document, John. This is a legal document we're talking about. What you make it take literally? It's a legal document. I'm reading it.
I'm saying like some of the clauses when it says like owning debt to Jews, like that's not really applicable today. You can't necessarily look at
we're doing analysis of a legal document. So we have to look at it through a legal lens.
Scootage, like how are you going to apply a scootage today? Like it's just like that's what I'm saying. It's subject to interpretation, right? It's not that black and white because you're viewing it as a black and white. I think what you did is you just read it and then you just took it literally, and that's fine. But when you want to apply it, you need to also have some discretion as well too when you're reading this document.
I'm having discretion and I'm trying to break it down. I'm trying to have a whole breakdown. John, I'm being serious. I'm taking you seriously. I'm having a serious conversation with you about.
Okay, I'm telling you right now that what you need to take into consideration when you're reading that document is that it's subject to modern interpretation, in that there is some. Like you can't necessarily, because it was written in Latin and then translated into Old English. But John, that specific clause,
you want to use the document in the court of law
to be undiminished. Yeah, I would say this in front of a judge. Yes.
Okay, so if you want to use the court of law, you have to look at the whole document. See what the whole document means.
I would say this in front of a judge,
and they put it in clauses so it can be readable, so I can cite, so I can invoke specific
Exactly.
clauses. So
So I'm
yes,
telling you the nature of
yes, this
all
is
the
binding in
clauses.
law. Yes, as
You have to
God
look
is
at
my
the whole
witness, I will
document.
say
Look at
that
the law.
today. Yes, yeah.
You have to look at the whole document through a legal lens if you want to use it in courts.
I am. I'm telling you how it's viewed through a legal lens, and you're taking it literally, and I'm just saying
I
no.
can't
Like
say that. But I can
it's
see
not
how
to
it
be
is. I
taken
can't see how it's
literally.
learning right. Okay. When has it been used the way you want to use it? Give me some case law.
So basically, in that first clause, sorry, I'll go
I
back
want
here.
some case law. No, okay, John. Okay. You
I have a case law too. I
you
think
have
what
to
you're
come with me
doing
with
is you're
case
getting
law
ahead
of
of
how it's
yourself.
being used the way you're saying it's being used. You have to come with me to case law and say how the clause that clause. I mean, no,
Yeah. There's specific clauses that you can invoke in case law. Yeah, absolutely. So I'll read it again. So first that we have granted by this present charter have confirmed for us and our heirs in perpetuity that the English Church shall be free and shall have its rights undiminished and its liberties unimpaired. That we wish this so to be observed appears from the fact so the rights to be undiminished, liberties unimpaired. So there's specific clauses like this that even in constitutional law, like it's not black and white, right? There's nuances to different
I
situations
want
and
you to
how
cite
you
some
apply it,
I want you to cite
right?
case law. I want you to cite some case law and how it's being used the way you're saying it's being used. I want you to cite some case law then.
I
If you if you're saying I'm so
yeah,
wrong,
like
if you
I have yeah, like I can invoke clause 40. Yeah, there's case law actually coming up. So yeah, actually that ties into my presentation. So yeah, I can definitely do that for you.
I want you to go to the case law part. Go to the case law part first. Let me see. Case law.
Okay. Just let me just finish I'm a couple slides away, but hang on. So just an overview of the Magna Carta. So the Magna Carta was sealed by King John 25 Burns in 1215 and is still binding upon the crown nation today. It's binding upon all crown nations to recognize the common law and provisions of the Great Treaty. Can be invoked by any citizen of the crown. No parliamentary statute supersedes any of the 60 clauses when successfully invoked. Any crown employees can be tried for high treason if any of the 60 clauses have been broken beyond a reasonable doubt. So broken beyond a reasonable doubt. That's a key right there, right? So here's a couple legal terms here. So this is just for you to help with the case law here. Nunc pro tunc. This phrase, which signifies now for then, is used to express that a thing is done at one time which ought to be performed at another. Leave of court must be obtained to do things nunc pro tunc, and this is granted to answer the purposes of justice, but never to do injustice. The judgment of nunc pro tunc can be entered only when delay has risen from the act of the court. And then interlocutory decision. I hope I'm saying that right. Interlocutory, I think.
Interlocutory. It means the conversation partner.
Interlocutory, yeah. Is a legal
like
term.
Interlocutor is a conversation partner. So it's interlocutory. Interlocutory decision.
Yeah. Is a legal term which can refer to an order, sentence, decree, or judgment given in intermediate stage between the commencement and termination of a cause of action, used to provide a temporary or provisional decision on an issue. Does that make sense? I just want to make sure I'm not, going too far. But does that make sense? Hello? Okay. I don't know. All right. So this is case law here. So this is the case of the Canadian Nationalist Party v. City of Saskatoon. So the City of Saskatoon applies pursuant to Rule 41.6 of Court of Appeal Rules to quash an appeal filed by the Canadian Nationalist Party, Inc. Saskatoon says CNP was required and failed to obtain leave to appeal the decision under appeal. It also contends that CMP's appeal is manifestly without merit. So this is basically the city. So yeah, hang on. It goes in the background too. So just give it. Hang on. For reasons that we follow below, we are of the view that Saskatoon's application must be granted. In February of 2020, CMP filed a statement of claim against Saskatoon in Court of Queen's Bench, seeking damages under the Canadian Charter of Rights and Freedoms, and a declaration that Saskatoon had infringed its ability to democratically compete in the most recent federal election. CMP alleged that the infringement occurred because Saskatoon had denied its request to use the space in City Hall for purposes of party-related informational sessions and candidate nomination, while at the same time permitting other political parties to use the space. CMP said that Saskatoon had denied its request for denominational purposes, so either that would be religious or political reasons, thereby violating the charter and causing CMP to suffer financial costs associated with obtaining federal eligibility and to incur marketing costs associated with promoting its visibility as a political party. Does that make sense?
I mean, I'm hello. Can you hear me?
Yeah, I can hear you.
Yeah, I mean, let's keep going because it's like, I mean, we already have a conflict just from the interpretation of the Magna Carta. So I'm just gonna have to keep listening to you, but it's still, I still see where the problems are coming in, because if you say it's denominational and this, that, and the third, but how is that protecting that first clause you're talking about? Because it's talking about the Church of England. So if you're trying to use the Church of England clause, how does that relate to your case? And that's, so it's a lot of problems that I see. It's a lot of holes that I see in trying to use the Magna Carta if you don't look at the whole legal document and look at its fluidity, look at its interpretation. Even you said, oh, some things are subject to interpretation, some things are not subject to interpretation, but you're trying to use it as legal document.
Just because
You have to have look at the whole.
yeah, like that's supposed to be keepers of the faith. You're supposed to not supposed to discriminate based upon political or religious regions. And being
Yes,
the city of Saskatoon, they are a crown corporation, and therefore they are bound to swear an oath to uphold to be keepers of the faith.
I still don't see how the Magna Carta protects you in this instance. I don't see how the Magna Carta necessarily
because it talks about the heirs of perpetuity. Like, so basically, like I said earlier, if there's any contract broken between Her Majesty the Queen, so any like Her Majesty's representation, you're supposed to seek redress. You're supposed to write a letter to Her Majesty the Queen, and if 40 years have passed and no redress has been obtained, you could practice lawful dissent because that contract has been breached. Because the heirs of perpetuity is supposed to follow freedom of church's election, and if you don't enforce that upon the citizens of the realm, then you're not keepers of the faith. Is basically what that says. It's neglect. It's legal neglect.
That's where our issue comes in, because I have a different reading of the Magna Carta. Just from reading it, I think you're reading the Magna Carta incorrectly. I'm be honest, I think you're reading it incorrectly.
No, because it also says to all free men of the kingdom also granted, and our heirs in perpetuity.
Yeah, but I have to keep going back to the same thing. I think you're reading it incorrectly
it's
because
all one clause. It's
not all one clause. It's a different set. That starts a different set of delineation.
That's one clause. It's all in, if you go back, it's all in one
It's not
clause.
one clause. The clauses are not even really there. The clauses are just made for readability. It that's not what it means. Yeah, you're misreading it. I think I'll be honest with you, I think you're misreading the Magna Carta.
Okay.
I really think in good faith that you're misreading the Magna Carta. I think you're misreading it.
You okay. Like I said earlier, it was translated from Latin to English, Old English, and is subject to modern interpretation. So it's not to be taken like literally. But at the same time, that first there's specific clauses for readability
But you're
and
using
to
it in a legal
invoke it.
setting, though.
I don't
But
think you're legally trained enough. I don't think you have enough information outside of the. I think what you need to do is instead of just reading the Magna Carta and then taking it literally, and
yeah, but I'm
and
common
lawyers
sense.
and no
I'm
and
common
listen. I'm a teacher here, okay, and I'm going to tell you right now what is fact, okay, and I'm telling you that if you talk to any lawyer, they will say that it is subject to modern interpretation, that some of it is not enforceable by law. Like especially when you're dealing with like constitutional law, nothing is necessarily black and white. And actually, in the case law tier, it also says that as well. It's not necessarily black and white, uh, but at the same time, if you can prove beyond a reasonable doubt that clause has been violated, has been impeded, if there's no doubt whatsoever, then yeah, you can definitely invoke that. Or if you can also invoke deny or delay justice, you can also invoke that clause as well too. But there's some clauses that are just like when they talk about scootage or anything like that, like it was translated from Latin to English, right? And that's really hard to apply, right? But there is clauses that are clear cut and are binding upon her heirs and the barons, right? And that also these rights are also granted by the free men of the kingdom. So yeah, that's very clear. Clause 40 is very clear, and Clause 61 is very clear as well. The other ones are questionable. Like you can maybe, I'm not saying that all of them are bad. I'm just saying you'd have to go through them and you have to find a specific case law. I'm not saying like there's a black and white cookie cutter situation when it comes to these things, but you have to keep in mind too that when you have to, the reason why they put them in different clauses is that so you can apply them in case law. Because like even all the laws, like it's subsection 2-1, they divide them up so it's readable and you can actually apply it in a certain situation, right? I don't know if you took like law. So I took like basic law, like so you read like a case law, and then you decide, okay, where does this specific law apply to which specific situation, and 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 then what law has been violated, what law hasn't been violated, and so that so it's readable and it's also applicable in today's age, because it's very these matters can be a little bit gray, even the even the Charter of Rights and Freedom. The reason why I kept it as simple as possible, in terms of like you can still assert your rights, and use them, and that you can let them know that you are practicing lawful dissent and that you had there was a breach of contract by Her Majesty. You can still do that today. It's just that there's so much nuance that goes into all the laws. It's just like if you're reading it literally, it's not necessarily like the right lens to read it by. You know what I mean? Like if you're reading all the clauses literally, then it's not. Like there is like clause 1. I'll tell you right now, clause 1, clause 40, and clause 61. Yeah, you can read those more literally and you can apply them, but the rest of the clauses, it's really it's a gray area. But those 3 clauses are very clear and very concise, right? So what I do is like maybe do some research, like the history and how the Magna Carta was like inspired, like the Bill of Rights, the Declaration Bill of Rights, just because you're American, and how it's infused into law, and so basically it complements common law, right? It's not, and there's some clauses in there that are used to be the last extent. Like if there's no justice, if no justice has been obtained, it's a last resort, right? So that's why it's in there. This is to be used sparingly, but I'm saying like any private citizen of the realm can use these clauses. But for you, I would probably say, just because you're American, I would say I would like go research like how the Magna Carta, like research like Philip Koch, and see how he interpreted the Magna Carta to inspire the Bill of Rights, right? So it comes out like different. Like there's different fruits that come out of this this document, and it applies to specific countries. So I'm doing in the context of Canadian law and Canadian case law. So it might be a little bit different for you. So I would just suggest that you research like Philip Koch and the Bill of Rights, and then how that would inspire how the Bill of Rights was inspired by the Magna Carta. But yeah, this is specific, and I think
no, we could do this, but that's a whole different story.
Yeah.
The children of the Magna Carta, what the Magna Carta influence is a whole different story. We can get into all that.
That's the thing you have to take into consideration as well, too, right?
I'm trying to say that the specific application that you're trying to use the Magna Carta for. I think in this situation you are misreading the Magna Carta.
So you're saying that there's no religious freedom for the subjects of the crowd, or it's all free men.
But
so they don't have religious freedom. Is that what you're saying?
I'm saying that your case is not established in the Magna Carta. It could be established in other places in common law.
You haven't. Okay, this is the problem. I haven't even read you the case law yet, and you're already making that assertion. Why are you making that assertion?
Okay, read me case law. Read me the case. I asked you to read me case law. I asked you to read it. I
will invoke a clause.
I asked you for it.
I will invoke a clause.
I asked you for it. I did ask you for it.
Okay. Okay, I'll keep reading the case clause. So I'll start from the top. Travis Patron, who is the sole director of the CMP, has represented CMP in all court proceedings related to the action thus far. Mr. Patron is not a member of the Law Society of Saskatchewan. No assertion was made that he was a member of any law society. In October 2020, Saskatoon applied to a Court of Queen's Bench Chambers judge, under Rule 234-2, I think that's it is, of the Court of Queen's Bench rules, for an order that the CMP be represented by a lawyer in the action. The application was adjourned once at the request of Mr. Patron, and the CMP was ordered to serve and file any affidavit materials upon which intended to rely prior to the return date. CMP did not serve or file any materials. That's key right there. The Chambers judge granted Saskatoon's application, or the CMP be represented by a lawyer in the action, and also the CMP not be permitted to take any further steps in action without a lawyer. He summed up his reasons for granting the order by saying, the subject of this action is complex, if only because the charter aspect to be dealt with without unnecessary complication or substantial lengthening of the proceedings. Cases involving the interpretation and application of the charter require that the representatives of the litigants have legal training, expertise, and objectivity. Typically, it is a lawyer who has these attributes. Typically, but not always. It's not a sweeping statement, but that's mostly true most of the time. It is common ground that Mr. Patron is not a lawyer. There is no evidence that he has any such training or expertise, as he is directing mind of the plaintiff. It is unlikely that he has the objectivity that is sought in such complex matter. The circumstance of this matter are the kind of circumstances which Rule 2-34 exists. This is the kind of litigation that requires a corporate party to be represented by a lawyer. The plaintiff in this action must be represented by a lawyer. 4 days after the Chamber's decision was rendered, CMP filed a notice of appeal. Without seeking leave of this court to do so, the grounds of appeal are set as follow. That the appeal is taken upon the following grounds. So this is basically that was the court's case / the city of Saskatoon. Now this is the CMP making their case. That the appeal is taken to be upon the following grounds. The Court of Queen's Bench for Saskatchewan has ruled against granting Travis Bertrand the leave to represent the federally sanctioned political party he founded and continues to lead. The judge presiding over the matter claims Bertrand is not a lawyer and has decided that the Canadian Nationalist Party leader, chief agent, and sole director is not eligible to represent the corporation in the court of law. Mr. Bertrand holds sole directorship of the corporate entity of the Canadian Nationalist Party and is best suited to act on behalf of the organization in public affairs. It's a key statement right there. There is no person better suited than Mr. Bertrand to act as lawyer on file and to make decisions as pertains to public representation of the Canadian Nationalist Party. The allegations against the current government administration are most serious for democratic and constitutional integrity of Canadian society. The Canadian Nationalist Party was unconstitutionally excluded from the most recent 43rd federal election after requesting and being denied unambiguously the liberty of being permitted to host a public event and communicate their policies after issue of the electoral writ so this was the most recent federal election between September 11th and October 21st, 2019. The plaintiff maintains that this represents a failure of the government of Canada to uphold the democratic mandate. Denying Mr. Bertrand the ability to continue serving as lawyer on the file potentially be neglectful of the inherent dignity of the human person and damage public confidence in social and political institutions which are designed to enhance participation. Maybe I'll read that again. Denying Mr. Bertrand the ability to continue serving as lawyer on file could potentially be neglectful of the inherent dignity of the human person and damage public confidence in social and political institutions which are designed to enhance participation in society. So there's definitely some cases in. I'll stop there. Do you have any questions so far? Hello? 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 Oh. Yeah. Yeah. So there's actually a case in the constitutional law. I don't know where it is. That you can. It doesn't necessarily mean that you are a martyr for the cause or anything like, or a spokesperson for public institutions or anything like that, or political institutions. But there is case law where you can cite when a constitutional claim has been made. You can cite it is for the public. It is in the public interest.
Hello, can you hear me?
Yeah, I can hear you.
Jonathan.
Do you have any questions so far? I know I kind of go in a monotone voice, but it's a legal document, so I don't.
Jonathan?
Do you have any questions? Hello?
Jonathan.
Hello? Yeah, I can hear you.
Okay, I'm sorry about that.
Okay.
I got a second. What I was saying, I forgot even what I lost my train of thought. I was about to tell you something about I was about to say, okay, it was something about what you read before. Okay. I was about to say, in Canada, is it possible to represent yourself in a court of law? Can't you represent yourself in a court of law?
Absolutely, yes. And they actually admit this in the claim as well too.
But because I read it before, it says in some cases you need a lawyer. Because I go back to the part where it says in some cases you need a lawyer.
For sure.
There's no self-representation.
Okay. So what about it specifically?
I just remember that you say that one set of things you have to have a lawyer. Who said you have to lawyer? The law said you have to have a lawyer.
Yeah, that's part of the court proceedings. Yes.
The law. So who wrote this court proceedings? Who wrote this court proceedings? The clerk.
I'm
The
assuming
law
so.
clerk
Yes.
or something.
Yeah.
The
I
law
can maybe
clerk said you
research
had
that.
to have a lawyer.
That's according to the court proceedings. Yes. That's their claim, right? And then I'm just getting into the CMP claim.
In what? In this action, except through a lawyer.
Yeah.
So the plaintiff must be represented in this action by a lawyer. Why does in what action does the plaintiff have to be represented by a lawyer?
In terms of the Constitution claim being complex and the objectivity to it, in most cases, the courts, they want to make sure that not any Joe Schmo is making a constitutional claim, so they want to make sure that the claim is as legit as possible. They also have a thing that's called the Rothman's test. So the court basically said, I could basically sum it up for you, is that okay? So if you haven't proven yourself to be a lawyer, you need to submit affidavits to prove that you can be objective and to address the constitutional claim against you, right?
Okay. So basically two sets of court. So this issue is being filed in the constitutional court, not being filed in a regular criminal court. It's a constitutional court, right?
Court of Queen's Bench. Yeah, it's a higher court. Yeah, it's the highest court in the province. I don't know the states, but yeah.
Okay, so the Court of the Queen's Bench is a constitutional. So in the Court of the Queen's Bench, you have to have a lawyer, but in a regular court, in a regular court of first instance, in a regular criminal civil case of first instance, you can self-represent yourself, but in the constitutional court, you have to come with a lawyer to a constitutional court, right?
Or you can prove yourself to be competent in the constitutional violation by submitting affidavits, as well as there's also a thing. That's why I mentioned earlier about nunc pro tunc. Is so now he's making the case to practice nunc pro tunc, as it's in the there is constitutional law. So where you can incite, it is in the best public interest to be self-representation. It's in the public interest because it could be potentially neglect. So Mr. Bertrand here, basically it's best self-described on the case law. Denying Mr. Bertrand the ability to continue serving as lawyer on file could potentially be neglectful of the inherent dignity of the human person and damage.
Let me ask you this. Okay, we have a lot of questions about Mr. Bertrand. Does he have a pending criminal case happening? Does he have a pending criminal case?
He's let's see. He has 2 indictable offenses right now. One for mischief, and the other one for break and enter. Has not been found guilty for, but that's the accusation of the Crown prosecutor.
Okay, the mischief is what? Is it a case involving 2 women?
No, that one is assault and battery. That's a private matter. That's not based upon the corporation.
Okay, but
he's incarcerated right now for the indictable offenses of acting on behalf of the corporation. So basically, seizing civil asset forfeiture. He wrote a what did you say? A notice of seizure to the people of the Redverse Legion. That it is a property of the Ministry of National Faithism.
Who's the Ministry of National Faithism? Who started the Ministry of National Faithism?
Travis Bertrand.
And so the Ministry of National Faithism is attached to the CMP, or I know it might be 2 separate organizations, but it's
part of the Canadian Nationalist party tribunal jurisdiction. So it's an independent lawful jurisdiction that he asserted.
Case.
So it's property of the CMP, but it's still public. It's not private. It's still public. It's as a public civil asset forfeiture in accordance with Clause 61. We can go over Clause 61 if you want.
Clause
You want to go
61
over
of what?
Clause 61?
Of what the Magna Carta?
Yeah, it talks about civil asset forfeiture.
I mean, that's one thing, but we had but okay, we can talk about that if you want to. Yeah, we can talk about that. Let's go to Clause 61.
Okay. Yeah, there's a lot of moving parts to this. But yeah, we can go to Clause 61. I'll just
I have it right here. I have Clause 61.
Okay. Clause.
I mean, I have it right here.
Okay, you want to read it out?
Yeah, okay. I'm reading what is the 61 on my computer. It says, since we have granted all these things for God, for the better ordering of our kingdom, and to allay the discord that has arisen between us and our barons, and since we desire that they shall be enjoined in their entirety with lasting strength forever, we give and grant to the barons the following security. The barons shall elect 25 of their number to keep, and cause to be observed with all their might the peace and liberties granted and confirmed to them by this charter. If we, our Chief Justice, our officials, and any of our servants offend in any respect against any man or transgress any of the articles of the peace or of this security, and the offense is made known to 4 of the said 25 barons, they shall come to us, or in our absence from the kingdom, to the Chief Justice to declare it and claim immediate redress. If we or if we or in our absence abroad, the Chief Justice makes no redress within 40 days, reckoning from the day on which the offense was declared to us or to him, the 4 barons shall refer the matter to the rest of the 25 barons who may distrain upon and assail us in every way possible, with the support of the whole community of the land by seizing our castles, lands, possessions, or anything else or anything else saving only our person and those of the queen and our children, until they have secured such redress as to have determined upon. Having secured the redress, they may resume their normal obedience to us. Any man who so desires to take an oath to obey the command of the 25 barons for the achievement of his ends, and joins with them in ascending us to the utmost of his powers, we give public and free permission to take this oath to any man who so desires, and at no time will we prohibit any man from taking it. Indeed, we will compel any of our subjects who are unwilling to take it to swear it at our command. If only one of the 25 barons dies or leaves the countries, or is prevented in any other way from discharging his duties, the rest of them shall choose another baron in his place at their discretion, who shall be duly sworn in as they were. In the event of disagreement among the 25 barons on any matter referred to them for decision, the verdict of the majority present shall have the same validity as unanimous verdict of the whole 25, whether these were all present or some of those summons were unwilling or unable to bear. The 25 barons shall swear to obey all the above articles faithfully, and shall cause them to be obeyed by others by the best of their powers. We will not seek to, we will not seek to, will not seek to procure from anyone, either by our own efforts or those of a third party, anything by which any part of these concessions or liberties might be revoked or diminished, should such a thing be procured. It shall be null and void, and we will at no time make use of it, neither ourselves or a third party.
Mm-hmm. It's a long one. So it mentions seizing castles, lands, possessions, so being like crown public property.
If you're going around taking crown public policy without these 25 barons, like who are the 25 barons?
Okay, I think you're yeah, I knew you were gonna say that too. That's so like the thing is that's what I'm saying, you're swearing an oath to the 25 barons. And it's up to the 25 barons to uphold the clauses of the Magna Carta.
But who are the 25 barons?
The 25 barons are still existing today, and are still.
Have they agreed? Have the 25 barons agreed that you could go take crown property? Have they agreed upon that?
Yeah, if there's legal neglect from the. Yeah, it is part of the contract. Yes.
Have they agreed to your actions? Have these 25 barons agreed to your actions? Have they said CMP?
Yes, you swore an oath to them. Yes, it's part of the contract. Yes.
No, but have they given you your approval? Have these 25 barons given you their approval?
Yes.
They've given you approval.
Yes.
In writing. They have it in writing. They gave it to you in writing.
They don't have to give it in writing. They have. It's part of the contract.
What you mean? You have to get it from the barons. The barons did the barons give you a verbal agree? Have they verbally approved your actions yet? What approval have you got from these 25 barons to do this?
So you swear an oath to 25 barons when no redress has been obtained. You have to get redress from obtained in order for you to. This is part of being practicing lawful dissent, right? So you're guaranteed by the right of the 25 barons to seize any castles, lands, or possessions, any of those the queen or children until redress has been obtained.
Barons have to agree to do that. Don't the 25 barons have to vote?
Yeah, it's already in the contract already. When we swear an oath, you swore an oath to them.
Okay. When did 25 barons vote for you? When did the 25 barons vote for you to do any type of confiscation of crown property? When did the 25 barons do that? Okay, look. In the event of disagreement, so they have to agree. Because in the event of disagreement, when have the 25 barons agreed? When have you got them to agree to this?
It's our lawful duty. Okay, it is a lawful duty to hold the administration accountable, and it is with the support of the community of the land, seizing castles, lands, possessions, anything else, saving our own person, of those of the queen and our children, until they have secured redress as they determine upon. So it's actually a lawful duty to do that.
Listen, no, it's not, because look. If any man they may take an oath to obey the commands of the 25 barons for the achievement of his ends, and to join with them in assailing.
Yeah, that's what I'm saying. When you invoke any of the,
have they joined you in taking crown property? Have the 25 barons joined crown property?
No, but you swear an oath to them, and then that's when you're practicing lawful dissent. And when you're practicing lawful dissent, like I said earlier, when called upon, any of the Crown Corporation employees must address the argument at hand. They must address any of the clauses contained within the Magna Carta. And if they don't, I'm just saying, if they don't address any of the clauses, this is how you gain redress.
No, it's not. The 25 barons have to have. The 25 barons have to lead you in this struggle.
No, they don't. The 25 barons, those you swear an oath to, shall refer to the matter of the rest of the 25 barons who may distrain upon and assail us in every possible way, with the support of the whole community of the land, by seizing our castles, lands, possessions, or anything else, as saving our own person and those of the queen and our children, until has secured such redress as they have determined upon. Having secured the redress, they may resume their normal obedience to us. So this is referring to, this is going back to your interpretation in clause 1. You're saying it has to be the 25 barons that seize the lands and castles. I'm saying this is, you swore an oath to the 25 barons, and if no redress has been obtained, it is with the whole support of the community land, so the support of the 25 barons, to seize castles, lands, possessions, until that argument has been addressed by any of the crown employees. Yeah,
you totally misreading Magna Carta,
no,
man. You're misreading.
No, I'm not. No, I'm not.
You're misreading them. I swear to God Almighty, you're misreading it. I swear to God Almighty, you're misreading the Magna Carta terribly. You terribly misreading the Magna Carta from the ground up. Terribly, you terribly are from the ground up.
I think you're terribly misreading it. You think you don't have any rights, so I don't know. You don't think we have any religious rights, according to it. So I don't know. Who's really misreading it? What's even the point of this? You know, what's even the point of this if we don't have any rights? You know, if we don't have any religious rights, you know. So yeah.
But that's not my point. You're misrepresenting what I'm saying. You misrepresent what I'm saying, John. I'm saying that you're misreading. That's it. That's all I'm saying. That you're misreading the Magna Carta. From the ground up, you're misreading it. From the top to the bottom, you're misreading it.
If we, our chief justice, our officials, or any of our servants offend and respect any man or transgress any of the articles of the peace or of the security, the offense is made known for of the said 25 barons, they shall come to us, or in our absence, from the kingdom of the chief. So they don't have to be present. They even said it right there. The kingdom of the chief justice, to declare it and to claim immediate redress. If we, or in our absence abroad, the chief justice, make no redress within 40 days, reckoning from the day on which the offense was declared to us or to him, the 4 barons shall refer the matter to the rest of the 25 barons, who may strain upon or assail us in every possible way, in support of the whole community of the land, by seizing our castles, lands. So basically, if your interpretation is it's only 25 barons that can do this, the way you're interpreting it.
You need the 25 barons. This is an action for the barons to take action. The barons, this Magna Carta. This Magna Carta is giving the barons the right to act on behalf of the people against the king if the people do not get redress. But if you don't have 25 barons who qualify to act against the king, to assail the king on this front, you have no legal claim.
But if I go off of your interpretation, only the 25 barons can do it.
Yeah, that's what it says.
So we have no rights then, I guess.
No, I'm just saying that the Magna Carta is not, you're misusing the Magna Carta. That's all I'm saying.
We have no rights then. We have no religious rights. We can't gain redress. According to your interpretation,
you're misreading the Magna Carta. I mean? That's the only statement.
What's even the point, right?
I'm only making one statement that you're misreading the Magna Carta. That's the only statement I'm making. That's the only assertion I'm making that from talking to you right now.
You made the assertion that we don't have religious rights.
That's the only assertion I'm making.
Yeah, you also made the assertion that we don't have religious rights as well. So I mean, it's just like, well, what's even the point of it? Let's just burn it to the ground then.
I never made the assertion I know religious rights.
You know what I mean? I think what you're doing is you read it and you
the Magna Carta. That's all I'm saying.
You don't have any other information that I'm sorry for being facetious, but you read it, but you don't have any other background information to it. Now, what I could do is I could send you some links
towards the application of it
And there's many websites with it.
that our party has used.
I have all these things I can find things the Magna Carta. There's so many by Magna Carta. I'm just saying flat out period that you are.
I mean, like you wouldn't be the first one to say that we don't have religious rights, and that only the 25 barons. This only applies to the 25 barons. You know what I mean? It's just like, even though it highlights all free men of the kingdom, it also applies to, in the first clause, the freedom of churches' elections. I think what you need to do is, instead of just like memorizing it and just
John
and reading it just without any other information,
can you hear me?
I would get more information.
John, can you hear me?
On the application of it, because you don't have any information on the application of it. You just read it.
You don't either.
And then you're telling me that we don't have any religious rights when it even says it on there.
I didn't tell you that you didn't have
I don't know, like, what is even your point? Like, what's even the point of even invoking this in the first place?
I never said I have religious rights. All I said is that you're misreading the Magna Carta. I didn't say you didn't have religious.
That we don't have, like, citizens of the realm don't have religious freedoms according to you. It's only to the.
I've never said that. I've never said that.
You implied it, though. You implied it.
I never implied it.
You did.
I never implied it.
You did.
I never implied my religious right. Never implied it. I never implied it. Only thing I ever implied is that you're misreading the Magna Carta. That's all I've ever implied.
But you said it's all free men of the kingdom. Also, their heirs. Hang on, let's go back. Let's see here. Where was it? Shit, that was way back. There we go. Where was it? There we go. Okay, to all free men of our kingdom we have also granted for us and our heirs forever all the liberties written below, to have and to keep for them and their heirs, and for us and our heirs. So you said because it also says liberties written below, you think it's only all free men of their kingdom. It doesn't apply to them. It just applies to the clauses
what are you
below.
Talking about?
Yeah, that's what you said. You said that. You said that. Own it.
For one.
You said it. So basically, you said because.
You're not listening to what I'm saying. You're not listening to what I'm saying. You're not even listening.
No, I listened to what you said. You said to all free men of our kingdom, we have also granted our heirs all the liberties written below. So you said to all free men of our kingdom, only liberties below you can invoke. You can't invoke this clause.
You can't invoke the.
What I'm saying is like if we can't invoke this clause, we have no religious freedom.
No, that's not necessarily.
We have no redress because that clause doesn't apply to you, to us, because according to you, it only applies to the church.
That's your assertion, not mine. I swear to God, that's your assertion.
No, you said that. You said that.
No, I didn't. I didn't say that. I swear to God Almighty, you're not keeping good faith. That's bad faith. You're not keeping faith. I never said that. I never said that.
You did say that. You can go turn back. Rewind. You did say that. You actually emphasized all the liberties written below.
I said that's for the church. I said that's for the church. I mean, first of all, every single right you have is not in the Magna Carta. The Magna Carta is not the only.
We don't have religious. That's only for the church. That's not for all free men in the kingdom.
Is the Magna Carta the only religious document in the British common law constitution? That's the only document? No. You have the English Bill of Rights. You have so many stuff. I'm saying that you simply not reading the Magna Carta correctly.
No, you're not reading it correctly because you're basically insinuating that we don't have any religious freedoms. It's only based upon the whims of the heirs and the parents.
Freedoms. I didn't insinuate it. I'm insinuating you're not reading the Magna Carta correctly.
I don't even know if you really have like a clear case right now. I don't even know what your argument is.
That you're not reading the Magna Carta correctly. That's my argument.
I don't even know. Like, okay, so we don't have religious freedoms, or we do? I don't know. It's
say that. I said you're not reading the Magna Carta correctly.
Because I mentioned denominational, and you're like, oh, I don't know if that applies to you in the Magna Carta. So what? We don't have religious freedoms or political freedoms?
I never said that because it's the Magna Carta the only religious document in the British common law constitution. That's the only document. No.
So basically, you're insinuating that we don't have religious freedoms.
I've never applied on religious freedom.
You did say that. You did say that when I was reading the case law. When I said denominational, yeah.
You were misreading the Magna Carta. That's all I said. I swear to God. Go check it out.
No, I'm not. Like what you basically when I was reading case law. Okay, man. I was reading case law, and when I mentioned the organization was discriminated against for denominational purposes, you're like, oh, I don't know if the clause 1 would apply there for you. So you just said that we don't have religious freedoms. You basically said that. Like you said it multiple times, and now you're backtracking on it. Now you're just telling me I'm misreading it.
Yeah, I said you're misreading the Magna Carta. Yes.
Really? So do we have religious rights or not? Can we claim that we were discriminated against religiously or politically, according to Clause 1, or not? Yes or no?
No, but I'm saying you're misreading the Magna Carta.
So no, we don't. We can't claim it. Okay. Gotcha.
I'm saying you're misreading the Magna Carta. Okay. I'm saying you're misreading the Magna Carta.
I don't know. I felt like this was going to be pretty controversial. But, I think what you need to do is, I don't think. I don't know if you're like. I know you're trying to be as honest as possible. I can tell, but I don't know if you're really being honest right now. To tell you the truth, when it comes to this. Because you insinuated that we don't have religious freedoms, and that
I've never seen where you didn't have religious freedoms.
Yes, you did.
Magna Carta correctly.
You did.
No, I didn't.
I don't even know. Like it just seems like you may be complicating things too much. Like, I don't know. Like the thing is, like I don't know. Like what? I don't know where you're coming from, man. Honestly, I don't.
I'm saying that you're not reading the Magna Carta correctly.
What authority are you?
None. I have common sense authority.
Okay. Yeah. Okay. Let's just continue then, because this is really, I don't know. This is, I think, I don't know if you're reading it through. I think what you need to do is you need to have I had a feeling this would happen, because you just like read the Magna Carta and you took it literally, and I'm saying don't take it so literally, and you're kind of getting confused by that. So. And I understand that, and I'm like, I don't want to like demean you anyway. I just like, it does take a while to comprehend, and you're from America, so you don't really have any political stake in it. So
is that about America?
I think America. What we need.
You're simply not reading the Magna Carta correctly. That's all I'm saying. Because that's everybody chat.
Right now, you're not reading the Magna Carta
you're not
correctly.
Reading correctly. That's all I'm saying.
You're denying that claim. I'm telling you, it was translated from Latin to English, and it is not all like to be taken literally. Like all the clauses are not to be taken literally, because some of them are not really applicable today. And I think you're taking it literally, but at the same time you're claiming that we don't have religious rights, or we don't have the right to do sin. You know what I mean? And so I don't know if you're really like you're claiming that I'm wrong, even though like I have a little bit more backstory behind it and the correct lens, whereas you just like read it and took it literally, and you just assumed that it's just I don't you just assume it's all binding. I'm saying it's not, and then you're getting kind of confused by that. So I'm just saying, like, you need to go back through the presentation, kind of just internalize it a little bit, and then make sure you have the right frame of mind when you're reading this document, and then you can apply it to case law. I
have you taken any like law classes in college at all or anything like that?
No, I was an economics student in college.
Oh, okay.
My little sister was a lawyer. My little sister's a lawyer. My little sister's a
Uh,
lawyer. I asked my little sister.
okay.
My little sister's actually a lawyer. My baby sister's a lawyer.
Okay.
I mean, when I was in high school, I was on the trial team. I went to the moot court competition. I actually used to do trial competitions in high school. I did trial competitions in high school, but that's as far as I went. I didn't do law past high school. The only law I did is legal, is financial law. I did financial law and I did the legal aspects of business, and I did financial law and legal aspects of business in college. I was an economics major, but I'm not a lawyer by profession. I'm not a lawyer,
Okay.
but I'm just using common sense that you're reading it wrong. I'm just common sense reading the document.
It's not though. It's you're not. I'm telling you right now, you're not reading it through a proper lens. I'm sure you're reading it, but like I'm saying is like don't take it literally. And you're like, what do you mean don't take it literally? Like I'm telling you right now, like you can't like take this literally, right? But there is clauses that does say take it literally, like clause 1, clause 40, and clause 60. You can take maybe clause 61 is a little bit tricky. Not really, because I basically laid it out. I laid out the foundation for you that you swear out to the 25 barons. If there's no redress have been obtained, you gain redress by seizing civil asset forfeitures. Right. So what I'm saying is you need to have the right context and the right
you're misreading
the right structure when you're reading it because you just read it and then
you get in a lot of legal trouble. What am I saying? That if by doing
why am I getting into legal trouble? You insinuate that we have no religious rights. So why am I taking advice from you, right? Why am I taking advice from you?
Rights.
You know
I'm saying
that why would I didn't ask for your advice.
Document. I'm saying
I didn't ask for your advice.
All I'm saying that you're misreading one particular document. I'm saying you're misreading one document.
You're misreading it. I'm telling you, you're misreading it, sir. You're misreading it, and you're not getting that point. Because you don't understand it, and you're taking it literally. I'm telling you not to take it literally, all the clauses literally, but there's some instances where it is specifically stated to be like clause 1, the freedom of church elections to be unimpeded. That's a clear case. Clause 40, the right to deny or sell or delay justice. Clear case. Clause 61. Okay, so clause 61, you have to understand a little bit of a more nuance, right? That's a little bit more tricky, but you can't even like get clause 1. I mean, I'm not trying to demean you anyway, but I'm just saying like you need to have a little bit more back knowledge, a little bit more proper context, the right frame, right lens to read the application. And I hope I did this presentation today, and maybe we can go back, and we can rewind and watch the presentation and take that information, use that lens for that information, and then read the document. And I don't like that's what I'm telling you right now is you're not reading it through a proper lens. You're reading it through like a literal lens, and then I'm telling you that your lens is wrong, and you're not really listening, right? So what I'm saying is we can go back. Maybe what we'll stop today with the presentation. Maybe we just go discussion, or maybe we can talk about something else. It's a very heavy topic, so maybe I over bombard you. I was just like I gotta be ready, but I think
I'm not over bombarding.
I'm not saying this to be facetious or anything like that. I'm saying this to be like honest as possible, in that you don't have the proper context in reading this document.
I think you're reading what you want into the law. What I think you're doing, I'm gonna tell you the truth.
No. I'm telling you right now. I'm telling you right now. You insinuated some very heavy things that you don't have the proper context for. And what I'm saying is you need to go back, you need to get the proper context, and then when you have the proper context understood, then you can read the clauses. Like reading the clauses itself, you can have your own like insinuations, you bring your own values and other knowledge that's not like, I don't know what your other knowledge is of English constitutionalism, but maybe you might project that. But what I'm saying is it's a kind of specific document that is specifically for the Commonwealth. And what I'm saying is you need to have the proper context when you read this. And I lead that. I can maybe go back. I don't want to necessarily read it because it's a lot of information. What I'm saying is you can go back on the video. You can read the information that I had for the beginning slides, internalize that concept, and then when you have that proper context and you're not taking it so literally, then you can read it and have a proper context. Like when I talk about swearing an oath to the 25 barons, and that they are only to make redress on certain claims, and they're only to make judgment, and also the first clause, the freedom of churches' elections. You did insinuate many times that the Magna Carta doesn't grant freedom of religion to all free men of the kingdom. Now, you could deny that now. That's fine. That's fine. But what I'm saying is, you just read the document, but you don't have the context behind it. Reading it, I hope I'm making sense. But you need to have a little more information. Maybe there needs to be, yes. And I'm telling you, like, and you're not, maybe you're rejecting it out of your own cognitive dissonance, but I'm just telling you that you need to go back.
There's no cognitive dissonance. You misread the
yes.
The Magna Carta is not dealing with the Magna Carta is not dealing with religious freedom of all religions. It's dealing with the free election of people in the church.
That is insinuation of the freedom of religion.
No, because you have
liberties of religion.
The Magna Carta stems from the Magna Carta. What? No, because that's insinuating the Magna Carta is the beginning and end of the whole common law constitution, and it's not. The Magna Carta is not the beginning and end of common law.
I didn't say it was the beginning of the end. What I'm saying is you're not reading it in a proper context.
Magna Carta is not the beginning and the end of common law, and that's what I'm saying. So there's no way that I'm not saying that you don't have religious rights. I'm saying that the Magna Carta is not dealing with religious rights. It's dealing with the rights of a free elected church. I'm reading it directly.
And that it also extends to all free men of our kingdom as well.
All free men of our kingdom.
It's in big letters.
All free men of our kingdom.
You don't have religious freedom according to the Magna Carta. I'm saying that's just blatantly wrong. That's blatantly false.
The Magna Carta is not a religious freedom document. I'm saying the Magna Carta is not a document.
Okay, I guess we don't have any rights then, and we don't have any religious rights.
They don't have any rights.
We could just,
I'm saying
throw away the Canadian Constitution.
That's all I'm saying.
Throw away the Bill of Rights.
All I said is you're misreading the Magna Carta. That's all I said.
Like I don't even know. The thing is, you need to go back.
Okay, I'm gonna tell you what it says. Okay, let's go again. Okay.
I don't think. Okay, I'm not gonna. Honestly, I'm not gonna go through this again because you don't have the proper context. It takes a while. It takes a while. No, I'm not being facetious. It took me a while too. I'm not, because you don't have the proper. You don't have the proper framework. You're not reading it through a proper lens. You're just taking it literally. And I'm telling you, don't take it literally. And you're like, what do you mean, don't take it literally? I'm saying, like, there's proper context as well as there's language in there that is not suitable for today's application. And what I'm saying is, you need to go back. You need to have a proper context. Go back with the information. Start there. Maybe do a little bit more research, and then you can, and then we can have a more fruitful discussion. Because this is not fruitful discussion right now. I'm just telling you right now, this is not fruitful discussion. I'm not being facetious or anything like that. I'm just saying, like, I don't think there's really any. I'm not saying you're arguing in bad faith. I just think, honestly, it's just it's just you just need a more context to reading it. And I'm not saying like you have to have the exact context as mine, but you're not listening to what I'm saying when I'm saying you need to have a proper lens when you're reading this document. You told me you hang on. You just read this document, but you don't know any other information beyond it. And I'm telling you, you need to go more research the information that is directly related to the Magna Carta.
Information I need to know.
And this took me a while too. So I just didn't read the Magna Carta in one day and like, oh yeah, I know everything. No, it takes a while to comprehend. And it was my fault. Maybe I put too much information in, but I think I did put some information in the beginning that you can go back, you can rewind on the video, and then you can also, from there, you can do some other research as well too. And then from there, you can gain the proper lens to observe the document. And it takes a while. Like it took me a while too. Like I'm still learning too, but I'm telling you right now, don't take it literally. You're just like, you're having cognitive dissonance and just like rejecting that case. I'm saying like no, this is like I'm telling you right now. Like I know like a lot of people don't want to tell. Like I'm just being blunt with you. Sorry, I don't know how else I could talk. I'm just being blunt. Okay, I apologize.
You're telling me to look at a legal document that you yourself said it was a contract that you yourself said that you're going to take into court.
I'm telling you that yes, yeah, it's true. I'm telling you it's true right now. It's not to be taken 100% literally. Do you want to talk about something else? Hello? Still there?
I'm here.
Okay, I'm sorry. Okay, let's talk about something else. Because we've been kind of at it for a while. Maybe do another time. Maybe we can address some of the comments in the chat.
Okay, we can address something else.
Yeah.
It just Claire says it just means that she says clear-cut projection is talking about you. She said it just means that anti-Semitic white nationalists do not have the right to assemble in the government buildings of Canada because they're denominational, i.e., divisive religiously, politically. The only thing at issue is the definition of denominational. Claire says that Pelou will get no thanks being the bearer of bad news. He says that Pelou's textual interpretation is impressive.
Of course, she would say that. She has. I have to tell you something about Claire. Claire has been hostile towards this before for a long time, and I think it's a reason why I don't associate myself with Claire anymore. She has sent me a lot of vile comments about our. She's basically justifying our rights being diminished because of our political affiliation. So she says that because of our political stance of ethno-nationalism, we have it's the right of the crown to discriminate us from assembling and speaking, and that comment is not in good faith whatsoever.
No, she's trying to take it a legal word, denominational. What does it mean to be denominational?
Political or religious in nature. And I've said that like 10 million times. And it's just like I'm not like that's the thing is like I don't. That's why I'm kind of like I don't listen to Claire Cause. I appreciate you. I know I appreciate you actually. Reading the Magna Carta actually, and actually addressing my arguments where Claire would just just say I'm just speaking nonsense. but she's obviously siding with you because just because you're trying to discredit my argument, and she hasn't, and she's from the position that because we are believing that we are denied justice, that she's based from the position that we're justified by the system to be denied justice, denied political redress, to be denied representing ourselves, because we're so-called anti-Semitic. That's not an honest position. That's not an honest position. I'm telling you right now. Right?
Hey, John, can you hear me?
And she also has a vendetta because she's a former lawyer.
Hey, John.
We're basically claiming that. No, we're basically claiming that we don't
John,
like.
can you hear me? No, can you hear me, John?
Yeah, I can hear you.
I was no way trying to invalidate your argument. I'm just trying to tell you the truth. If I see that you're misreading,
I'm telling you the truth right now. But the thing is, you're not like listening to me. That's the thing, and that's why I wanted to stop talking about it.
I'm not agreeing with you.
You're not listening to me, and
not
that's
agreeing
fine because you probably don't have any other frame of reference that you can read.
John, can you hear me? Can you hear me, John?
I can hear you. Yes.
I said not agreeing with you does not mean I'm not listening to you. I'm listening to you completely. I listen to every point you're making. Just because I don't agree does not mean I'm not listening.
Okay,
it's a big difference between agreeing and listening.
That's fine. And I just don't think I'm just saying it's not fruitful to keep going with this because it took me a while to get like the proper lens and how to read it and then how to apply it, right? Whereas you just read it, but you haven't really applied it, or you don't have any other information other than just the Magna Carta itself. And I'm saying, in order for us to keep moving on, we need to have proper context in reading the Magna Carta and not just reading it and taking it literally.
Okay. Right?
That's what I told you. And then that's the thing. It's not black and white like that. Right? It's not black and white.
Can you hear me? Can you hear me?
Yeah, I can hear you.
Okay, first of all,
it's not black and white like that.
Listen, first of all, that's why I wanted you to come teach Magna Carta. I don't want you to come teach the case. Just teach the history of the Magna. Okay, why don't you just teach the history of the Magna Carta?
I did do that, and I think maybe my job is done here. Is that correct? Maybe my job is done here, and I don't want to get in the weeds with Magna Carta because it took me a while. Like I'm not being facetious towards you, and you just read it in one day. That's fine. I respect that, but I'm just saying like it took me a while to get like to internalize like a proper lens. To read it and to apply it, right? And I think I could send you some links and maybe you can read it, but I think my job here is done, like in terms of like the history and how to like apply it and how and the different clauses that are actually how it's interrelated with Canadian case law or Canadian law. And I think that those are some simple maybe terms that we can go in, but when it comes to like the weeds per se, I think we are disagreeing on the lens that we are reading the Magna Carta, and I'm saying that you are, I don't know, you're taking it like literally, and I'm telling you not to take it literally, everything, and you're denying that. But I'm just saying like. Because of that, I don't think you're reading it in the proper lens, and therefore we can't really have a fruitful discussion. And therefore, I think we should just stop talking about the specific clauses, and maybe we can just go talk about the history and maybe debate about that, but just not talk about the specific clauses.
I mean, yeah, okay. Anyway, we'll catch up. I'll talk to you. I mean, this is good for this session. I gotta get some rest anyway. I gotta go back to work this evening. So yeah, but thanks for having me on again, John.
Yeah, no problem.
And then we might talk, but we might not make it about Magna Carta next time. Our next talk we might have let's talk about a different topic then. Okay, that's fine. Okay, we'll
and I understand that you're from America and that you don't really have any.
I don't think I'm from America. All I'm saying is that is we could agree to disagree, right? That's not a bad thing, right? To agree to disagree is not a bad thing. Can we disagree? We could. I don't mind agreeing to disagree.
Yes, and I don't say that lightly. I just think, yeah, you just need a proper context, and um, um, and legal is very tricky. So maybe I can't agree to disagree with it that you're taking it literally, but I don't know. I don't know if I can agree to disagree.
I said we could agree to disagree. Why can't we
I don't
agree?
know.
We
Can we?
disagree. Me, and you are disagreeing right now, right? We both disagreeing.
Okay. I'll say this. So I don't say that lightly because that can get you in trouble sometimes. I agree to disagree with you on the application of the Magna Carta, and that's fair.
Oh,
I'll say that.
Okay. Well,
I think that's a fair statement.
Why we disagree on the whole issue of the Magna Carta?
No, I'm saying we can agree to disagree on the application of the Magna Carta.
We just agree to disagree on the matter of the Magna Carta.
On the application of the Magna Carta. Because you obviously disagree on the application, right? So I can accept that.
We agree on the matter.
There's obviously different applications. That's fine.
No, we agree on the matter. On the matter too. We agree on the matter of it. We disagree on the matter of it. We disagree on the matter.
I can't. Your opinion that it's taken literally, I can't accept that as a.
No.
It can only be opinion. It can only be opinion. It's not a legal. It's not a legally binding.
We agree to disagree. I'm trying to say that.
I'm saying that we agree to disagree on the application of the Magna Carta. And I think that's a fair statement.
But we disagree on the matter. We disagree on the whole matter. If we disagree on the whole matter, in
terms of the interpretation, yes.
We agree to disagree on the matters, and that's fine.
The interpretation is precedes the application. So I'm giving you like a general statement. I'm giving you a general statement that we can agree to disagree on the application because there's obviously different applications.
The entire matter of the Magna Carta.
I'm telling you right now, you're coming from, and I don't want to be like facetious or anything like that. I'm telling you that we can agree to disagree on the application of the Magna Carta because there's a lot of different applications of the Magna Carta. I'm saying is that you need to have the proper context to read it so you can more effectively apply it to assert your rights.
And I disagree with all that, so I'm saying we disagree on the matter.
So we disagree on the interpretation
and the matter.
We agree to disagree on the application.
We agree to disagree on the entire matter of the Magna Carta.
Of the application.
The matter.
The application.
The matter. We disagree.
I'm giving you an olive branch, man. I'm giving you an olive branch.
Yeah, I
agree to disagree on the application.
I gave you the olive branch to begin with. I said. No,
and this is negotiating. I'm negotiating with you right now.
And
it's a broad term, and
the matter.
And I think for you to have a proper, and maybe I'll rephrase this, for you to have a proper application or a more effective. It doesn't necessarily have to be my application, but a more effective application of the Magna Carta is you need to have proper context in reading it. And when you have the proper context, when you read it, you can have a more effective application. It doesn't have to be my application. It could be your application. And that is a fair and educated negotiation of an olive branch to extend out to you.
Disagree on the matter. No, I disagree with you, and we should agree to disagree on the matter. We should
agree to disagree on the application. I want to be specific as possible.
No, the matter, the whole thing.
Agree to disagree. Agree to disagree on the application.
No, on the entire matter. We agree to disagree.
Because what you're saying right now is legally, like, if I'm going to agree to disagree on your interpretation, I know your interpretation is false. Like, it's just blatantly legally false. Like, to take the whole thing literally. right?
And I
I'm
disagree
not
with
saying
you.
you're not finding. I'm just saying that they're not
So
to be
we
taken
agree to
literally.
disagree on the
And
matter.
so you're taking it literally, and you're misreading it in that
I'm
way.
saying
So
we
like you're
disagree
just
on the
wrong.
matter.
Like I'm just going to tell you straight up, you're just wrong.
I know
But what I'm
something
saying
wrong.
is
So you disagree
to be like in a general matter, we can agree to disagree on the application of the Magna Carta.
on the
Because I
matter.
think you did question my application of clause 61. So that is a fair statement.
Matter.
And also clause 1 too. That's a fair statement. That is a fair statement. And you need to be more educated on the context of the matter, and then maybe we can have a more fruitful discussion, which is why I stopped the discussion.
I disagree with you on the matter.
Okay, then we could disagree to disagree on the interpretation, but I'm saying we can agree to disagree on the application.
We could
There's
agree.
different applications.
We could agree to disagree on the matter.
I wanted to be more specific.
But matter is the whole thing, because we disagree on the whole thing.
But I can't when I know something is just blatantly false, and then you look and you say, "Oh yeah, that's false. John was right. I shouldn't take it so literally." And then why would I validate that you have a some sort of valid point based off of an uneducated presumption?
You disagree with me. You disagree with me. So I'm saying we agree to disagree on the matter.
I'm saying I just want to be more specific because I don't want to like validate anything that's false.
And me neither. Me neither. So we have to agree to disagree on the matter.
But I know I'm right.
I know I'm right.
But you don't have the education on the context of the matter. That's the thing. I told you not to take it literally, and you're just ignoring me. You're just ignoring me. You're just being stubborn.
I have common sense.
I'm being stubborn too.
Right.
I'm being stubborn too, and I'm just trying to make a general statement so I don't validate something that's obviously false.
To disagree on the matter.
I'm not going to validate something I know is obviously false.
I know.
What I can do.
Disagree. I'm not saying to agree with something. I'm saying you disagree with me. I'm saying let's agree to disagree.
On the application, I'm saying more specifically because I don't want to be held to account to something that's truly false.
You're not going to be held to account if you disagree. You're saying okay. We agree that we disagree to disagree. Okay, we're going to agree that we disagree to disagree.
Okay, to disagree. Fine. If you want to use that terminology, sure. Let's do that.
We agree to
disagree to disagree.
Yes. There we go.
Okay. There we go.
I love you, my man. You're my man. You're my brother.
I didn't validate anything. I didn't validate anything false for the record. If anyone's watching, I didn't validate anything that's
false. Me neither. I didn't validate anything either. That's the first thing we do.
I know you're in good faith, but I just know from my standpoint, I just want to make sure I didn't.
That's fine. And
nothing doesn't be used against me in the future. You know what I mean?
So we agree to disagree to disagree.
Correct.
That's fine.
Okay.
All right. Talk to you later. On the matter. That's what.
Now, if you say that, I'm like, okay, fine. Yeah, that's fine.
Yes, on the matter. We agree to disagree. We agree to disagree to disagree on the matter.
Good. That's even more general than my. That's okay. That's fair. I can. I'm not that unreasonable, so okay, that's fine.
Good job. Good job. Good job, John.
I got what I want. You know.
Yep.
I'm an activist. You gotta fight for what you want. Right?
Win-win situation. See, he's always the win. With me, he's always the win-win situation. That's what I like, John. Yep. I like when we find a win-win situation.
That's
right. Fair. We got a win-win situation. We're gonna agree. We're gonna agree to disagree. Win-win. Okay, John. Me and you. Okay. Win-win together. All right, John.
Sounds good.
Talk to you later.
Okay. Right, bye-bye. So I can maybe read some of the chat here. That was quite the exchange. Let's see. Am I saying that right? Zubidia El Zina? SK, so I'm assuming secular Quranists isn't sending their best. Well, I think he had a really good. I think the problem is he just read it and then he took it literally, and I had a feeling this would happen. So I don't have anything against him. So Mr. Paleo. So he did good for the. It takes a while to grasp it. So I don't say that like to be facetious or anything like that. I apologize to him if I came across as that. It does take a while. So, but yeah, I think he did good with the information he had. So it's fine. And in case law, it's pretty complicated, but yeah. I mean, that's the thing with engage with the public. Be honest with them and maybe be blunt with them, and if they're willing to accept that, that's fine. If they're even listening to what you're saying, that's fine. John thinks he's a baron. I didn't say I was a baron. I said you swear an oath to the baron. So basically, you swear an oath to the 25 barons. You're practicing lawful descent until redress has been obtained. All the clauses of the Magna Carta are binding upon the crown when called upon to enforce them. So you have to call upon. It's your duty to call upon them. I think the issue would be like, as it pertains to like the issue with clause 1 was kind of the linchpin of the whole thing. When it pertains to freedom of churches elections and the heirs. I didn't mean for it to be like it was just an honest disagreement, and I didn't mean it to be like a blood sport or anything like that. And I think he's a very stubborn, and I'm very stubborn, so naturally conflict's going to concur. I had a feeling this might happen because I just knew he just kind of just read it, and I was like, oh, I don't know how he's going to take my criticism of his interpretation. Yeah. But you can go back and you can the information itself. There's a lot of moving parts to it. So it's law is not for the morons and the vegetables. Sorry, I should have made a disclaimer. This episode wasn't for the morons and the vegetables. This is very complex and nuanced and gray. So I apologize to the morons and the vegetables. You can watch somewhere else. So. Something about the F-13 amendment. This is a flight of fancy. Opinions. Tehran, what did Paleo make correctly? Did you even the thing is I don't even know have you studied the Magna Carta? Are you educated in it? So I mean you're entitled to your opinion, but it's not a fact, right? And just make sure you know the difference between the two. Claire, yeah. The messages you have sent me, obviously, you're very hostile towards our public, our party interest, and you basically justified them denying us justice. So I doubt that we can have a good faith conversation about anything, really, which is why I've distanced myself from you. Yeah. Yeah, like I said, yeah. This is what I'm talking about. This is the problem. This is the problem right here. Is these people like this that are practicing law. These are the problem. These are the people who selectively enforce the law. These are not keepers of the faith. Like I said, she's an atheist. And what else do you expect not being keepers of the faith? Right? Literally right there. You deny justice. You don't have any place. You don't have what is your justification, Claire? What is your justification to deny us justice? You have none. You're just a raving lunatic has-been lawyer who hates people exposing the system. You're not the first. Won't be the last. So that's fine. There's gonna be haters. That's fine. There's no justification of the law. It says that because you're an ethno-nationalist, that you're denied public space. Show me the law, and maybe we can debate it. But show me the law. No law has been set forth, so yeah, you're not a keeper of the faith. You're contributing to their agenda. So good on you, Claire. Blah blah blah. Yeah, there's a reason why I dismissed you, Claire, because of statements like that. I obviously exposed you for what you really are. Let's see. Yeah, Claire, you're pretty daft. So I'm probably gonna, you know what I'm gonna do? Yeah, you're blocked. Don't listen to your comments. I think the problem with Paleo is he's been hanging out with Claire too much influence. When he gets through he gets through that cycle, gets eventually sick of Claire. I think Claire has a vendetta out for my affiliation because it discredits her system. So there's no point in talking to hostile people. Let's try to derail disingenuously what you're trying to do. I don't think Paley was trying to derail anything I was trying to do. I think he was going at it honestly, and I commend him for sticking to his position. I'm just telling him, it took me a while to apply the Magna Carta, and I'm, just because you're loud and you're voiceful and you assert things doesn't necessarily mean they're right. You know what I mean? So obviously Tehran's Beilu's friend, so obviously there's some bias there. That's fine. You're entitled to your opinion. That's fine. Yeah. I'm not ashamed of it. If someone is libeling you and advocating for you not to assert your rights, then yeah, you do need to be censored. Yeah. I think the whole system needs to be censored. Then you need to overhaul. And there's some ideas I'd rather not say. Let's just say they need to be tried for treason. Let's just say that. I'm in my legal realm to do that. Thank you for that, though. Maybe one day Claire will be tried. Who knows? Maybe not by me, maybe not by somebody, but maybe by a higher judge. Who knows? Let's see if there's anything else. I think that's it from the chat. Anyway, that was a really good talk. I commend Pelu for reading the charter. It takes a while to get these things, and I just think that I just didn't want to go through the whole case law, and maybe I could do it now. I don't know. I was running on a couple hours of sleep, so I'm just kind of maybe I could just go run through it, and then because I did a presentation, I didn't let's just go through it. We'll go through the rest of it, and I will I stood up. So where were we? I was just gonna say where we were. Let's see. I think we were here. Okay. Oh shoot! How about that? Hang on, folks. I am tired. And I got a couple hours of sleep, so 6 o'clock to the beat. Yeah, but yeah, it was just. I'm saying I was telling him. He needs the proper context, and he wasn't accepting it, so that's fine. That's fine. Like I said, Rome wasn't built in a day, and like I said, I still have a lot to learn too. So I didn't mean it to be facetious or anything like that. All right, so I'm just gonna do it because I came with the slide anyway, so I'm just gonna continue. All right. Okay. So denying Mr. Tron the ability to continue serving as lawyer on file could potentially be neglectful of the inherent dignity of the human person and damage public confidence in social and political institutions, which are designed to enhance participation in society. Being a member of the Law Society of Saskatchewan is not an absolute requirement to represent a corporation in the court of law. By way of relief, CMP seeks an order that Mr. Patron be granted leave to represent it. Saskatoon appeals to quash a CMP appeal on 2 bases. First, it argues that the Chamber's decision was an interlocutory decision, and as such, CMP cannot appeal without obtaining leave. So it's basically saying that you can't even appeal without a lawyer of the Law Society of Saskatchewan. But we'll move on. Saskatoon also submits that in the circumstances of this case, leave should not be granted new pro tunc. Second, Saskatoon contends that CMP appeal should be quashed to Rule 41.6 of the Court of Appeal rules because it's manifestly without merit. CMP takes the position that leave to appeal is not required because its right to appeal is inherent, and the appeal raises questions that concern the liberty of the individual. In the alternatives, CMP says that if leave is required, the court ought to grant leave nunc pro tunc because the appeal raises questions of national importance regarding the integrity of the electoral process and the right to self-representation. CMP argues that the Chamber's judge was wrong to require it to engage in counsel. Mr. Patron submits that because he is the sole director of the CMP, he and the corporation are effectively one entity. He says he has the right to represent CMP because, in essence, it is the same as representing himself, even though Mr. Patron concedes that he's not a member of the Law Society of Saskatchewan. Sorry, maybe I cut that out. As well as explained below, we are of the view that Saskatoon's application must succeed. The Chamber's decision was interlocutory in nature. So this is in terms of not the appeal itself, but to represent himself in the court of law. And this doesn't seem, this is a court of appeals, so this doesn't seem, this in itself doesn't diminish the claim. It doesn't say that you have no claim. It's just saying that we're going to, until the decision must be quashed, that you can represent yourself in the court of law. Yeah, and yeah, and other lawyers, and I don't want to say the names. You might know them, or you might know them very intimately. Would say get a lawyer to represent yourself, but at the same time, in the same breath, say, nationalist, ethno-nationalist party are not allowed to speak and assemble. Who would have thunk it, As such, CMP did not have the right to appeal without leave. The circumstances of this case do not warrant the extraordinary step of granting leave nunc pro tunc. The Chamber's decision was interlocutory. I'm saying that right. CMP has no right of appeal without obtaining leave. Contrary to what CMP inserts, the concept of an inherent right to appeal is not one that is recognized in Canadian law. The right to appeal from a decision of a lower court exists only where and to the extent provided by statute. In Saskatchewan, the governing statute is the Court of Appeal. Rights of appeal are described in Section 7 and 8, which read in relevant part as follows. Subject to subsection 3 and Section 8, an appeal lies to the court from a decision of the Court of Queen's Bench or a judge of that court, of any other court tribunal where the right of appeal to the court is conferred by an enactment. If an enactment provides that there is no appeal from a decision mentioned in subsection 2 or confers only limited right of appeal, that enactment prevails. Okay, right. That's a little bit tricky. Anyway. Oh yeah, this is talking about individual appeals. Okay, that's the whole thing. So that's inhibiting. Basically, interlude is like inhibiting the process. If we go back to the other side, inhibiting a process in the middle of it, kind of thing. Inhibiting while it's in process. Basically, sorry, I'm just tired. Subject to subsection 2, no appeal lies to the court from an interlude decision of the Court of Queen's Bench unless leave to appeal is granted by a judge or the court. Leave to appeal is interlocutory decision is not required in the following cases involving liberty of individual. As can be seen where the Court of Queen's Bench decision is interlocutory in nature and falls within the scope of the Act. An appeal to this court is permitted only with leave unless the case fits into the exception set out in Section 8-2 or brackets 2. At a very general level, an interlocutory decision is one made during the progress of action and other proceeding that relates to some intermediate matter in the case, not the ultimate matter in the issue. Okay. Let's just keep going here. I don't have energy to read all of this. As a general rule, a decision that does not finally resolve the action may be considered final if determines substantial merits of cause of action or substantial defense. Deals with the matter that is central to the ultimate issue between parties. Oh, that might have been good. That's fine. Okay. Leave is not required. Okay, so this is talking about basically the liberty of the individual and how I mentioned earlier the liberty of individual and the corporation are one and the same, and it says it right that he and the corporation are one and the same, and they're rejecting the argument basically, and what else we could say? And then this bottom part here is just, going about the corporation obtaining legal representation. Again, sorry, folks. Running on fumes right now. Okay, let's just go to the summary and leave this for another time. But this is basically the case law, and they're just basically stating, and I'll go to the conclusion. I have it written down too. So this is the conclusion, according to them. In short grounds, CMP notice of appeal failed to identify any error on the part of the chamber's judge that would permit intervention by this court, given the applicable standard of review. The first Rothman's hurdle had not been cleared. The appeal is destined to fail. Accordingly, leave to appeal cannot be granted nunc pro tunc. So yeah, Rothman's test is basically a test that they use to make sure that a case doesn't fail when put to trial. And basically they claim that the CMP didn't submit any affidavits, and sorry, this is on the door. Yeah, the CMP didn't submit any affidavits, even though I have proof that they did submit affidavits, and therefore they didn't say the affidavits that were submitted couldn't, because they did mention the objectivity and the complexity of the charter claims. They didn't say that the evidence that was submitted didn't demonstrate that. They just said no affidavits were submitted whatsoever. So that really implies a select application of the law. And there's grounds definitely for legal malice there, especially when you have proof, that a statement from the sole director of the CMP that there was affidavit submitted, but according to the court there wasn't. Yeah, and these people. I just want to say. I just want to make a point because honestly, these people don't want you to represent yourselves. Obviously, we've been banned from a lot of institutions, and like, how can you say that we live in a free and democratic society when a federally registered party was banned from public buildings? Like, who can ban, especially a legally registered federal party? You can look us up on the Canada election site. We are a federally registered party, even though our website is down. So I don't know, like, how you can get redress. Like, maybe like people like Claire, like that's what they actually think about us. Like, that's what they actually think about us. And it's like, well, why are these people like practicing law? You know what I mean? Like, why are they keepers of the faith? Why are they keepers of the faith of these sacred institutions that hold a society together? If anything, it only breeds chaos. It's just like, okay, you say you're a democracy, but then you're like, and then you selectively enforce the law. And then another thing too is the leader of the CMP was charged with hate speech on frivolous grounds. I'm sure. Oh yeah, people like Claire would absolutely applaud that. Yeah, and that just exposes the system more. You keep exposing yourselves, guys. Just keep exposing yourselves. Like, if you're not going to engage in good faith, I mean, why even talk to you? Why even appeal my arguments to you? That's what I'm saying. Unless the arguments are in faith, right? It's not made to the whims of humans. I don't think we're really meant for that. I think that's probably what democracy is kind of subverted. We just kind of went from being to the whims of human beings. Now it's gotten to a point you're just basically capitulating with treason. That's what it is. So anyway, collusion's cost application was granted by the Saskatoon. CMP appeal was quashed in circumstances where the cost favor the Saskatoon is appropriate, taking account of the nature, the complexity of the application. We fixed the cost at 1,500. CMP is ordered to pay the cost. Fuck you. Fuck yourselves. So yeah, this is basically summary of the litigation here. So it condenses it down. So City of Saskatoon claim no other action to be taken by the individual sole director of the corporation CMP by invoking interlocutory decision. The CMP needs a member of the Law Society of Saskatchewan. That's short. Before any further action is taken, that request was denied by the Court of Appeal. Mr. Trump was able to carry on with the appeal, even though he wasn't a member of the Law Society of Saskatchewan. So they did address his arguments. Hang on, I'll keep going. It was required by the court rulings and proceedings that Mr. Bertrand prove he is a member of the Law Society of Saskatchewan, that if he wasn't, he submit necessary affidavits to prove the case, that process wouldn't be impeded, as to not waste any unnecessary court's time and resources. Travis Bertrand, sole director of the CMP, Inc., wanted the courts to practice nunc pro tunc, to not deny or delay justice, as the proceeding was of national importance, that the democratic integrity of the system was in question, that being a member of the Law Society of Saskatchewan wasn't an absolute requirement to represent a legally registered corporation. Denying access to a federally registered party for being denominational, religious, or political nature to promote and nominate candidates when other parties were allowed to use the premise for the same purpose is grounds to make the claim of the democratic system in question. Although the courts granted leave and acknowledged Mr. Bertrand's claim of appeal, they claimed that the practicing nunc pro tunc was to be used sparingly. They, Court of Queen's Bench, claimed that the Chamber's judge probably observed that Mr. Bertrand submitted no evidence affidavits, that he wouldn't have the objectivity to represent the corporation as it pertains to examining the complexity of the charter violation claim. They, Court of Queen's Bench, admitted that being a member of the Law Society of Saskatchewan was an absolute requirement, but denied access to justice in this particular case. Justice was denied for reasons unknown, even though the Court of Queen's Bench admitted it wasn't an absolute requirement to be a member of the Law Society of Saskatchewan to represent a legally registered corporation. It was still based upon the insinuation, appeal to authority, that evidence wasn't submitted at all to practice nunc pro tunc. The court failed to justify to deny the reason why the democratic integrity of the system was in question. It wasn't sufficient evidence other than citing Rothman's tests with the claim that no affidavits were submitted. No further explanation was made on objectivity and complexity of a charter matter other than legal discrimination based upon the sole director's affiliation with the corporation CMP Inc. No one should be denied justice on the matter of legal affiliation, which is why invoking Clause 40 of the Great Treaty, Magna Carta, is legally sufficient in this matter. To no one we will sell, delay, or deny justice. So I'm going back to the liberty individual. So as it pertains to the liberty individual and the corporation, they are inseparable by law. According to the Federal Department of Justice, Volume Crown Law, the Crown of Canada is a non-statutory corporation. So essentially, a corporation sole creates a corporation out of an office. Once the corporation is established, there's no distinction between the office holder and the office itself. Although the office and the office holder retain dual capacities, namely its corporate capacity and its individual or natural capacity, they are inseparably infused by law. Royal succession at the Canadian Crown as a corporation sole, a critique of Canada's succession to the Throne Act, 2013. And this is a statement from the sole director of Canadian Nationalists Incorporated, Travis Bertrand. The Saskatchewan courts also falsely claim that I filed no evidence in support of our application for the Court of Queen's Bench to grant leave to allow me to represent the corporation as a lawyer during these proceedings. despite an application we submitted on November 2nd, and which we additionally included the opposing parties' materials, this application was also verbally delivered during a court hearing on November 5th, which the justice seemingly failed to consider. And this is just more information here. I can post them in the chat too, or in the comments, but let's end the show. I don't know if I'm still broadcasting. Still two people watching. Cool. Well, thank you for going through that. I know legal is can be boring, but I think there were some interesting points to be made in there anyway, and I just wanted to finish it off. And, praise Pelu for coming in today. But yeah, that was quite the stream. Any other comments here? I'm really. Yeah, it is just your opinion. Yeah. Thank you. Thank you, Teron, for admitting that. Appreciate that. I know I sound like the bad guy, but I'm just saying, like, opinions don't matter in a court of law, supposedly, but, you know, if you have people like Claire practicing law, anything pretty much goes. It's pretty much a kangaroo court at this point, you know. I guess all colonies of the English clown eventually turned into the Banana Republic, so I don't know. Yeah, if you go in the mind of Claire Caw, that's probably what most lawyers think. And maybe this is, I don't know, maybe it's all I'm just saying. It's like exposing it for me. I don't know. I'm just here. I do this faithfully, and I don't know why Claire keeps going on my thing. I haven't seen her videos in a couple months, and I would rather distance myself from her. But she provided a good example for me, so I think I can't miss that opportunity. And maybe others, you know, you'll see it eventually, or maybe you'll see it. You saw it today. Apologize, this is like a 3-hour stream. I know a lot of people won't want to go through a 3-hour stream. Maybe I'll try to break it up into bits and put it in different sites. As this is pretty. I did a stream on this before, and my channel got sandbagged. I couldn't post anything for like a day, and then I got no warning. It was just like I literally couldn't access my channel. Like I checked like my phone, I checked my computer, and I couldn't even like access it. Like after I made a stream about this exact topic, well, about the case law specifically, not just talk about the Magna Carta, just about the case law in general. And maybe that had to do with the time I did it, and I don't know, but yeah, I don't have anywhere else to go to post anything, so I'm just posting things on here. But I think I should maybe break this up and post it in a different, post the good bits. And I apologize for the low energy. This is Ramadan, and I only had a couple hours of sleep, so I apologize. But yeah, I think I'll break this up, and I will. It'll be interesting to go through. A lot of interesting parts for sure. And I'm glad we went through that first part. And I had a feeling that this was going to happen anyway, so it's not a shock to me. So I'm not shocked by it. But I'm glad that we went through the first part today. So, but anyway, I think I'm gonna sign out here, and And I will who is this Zubaida El-Zina? Hey, why do you have that graphic photo? Like, you're making these claims, man. Like, what basis are you making these claims? Like, yeah, I censored Claire. So what? Said I have no rights. So what? Like, what were you supposed to do with these people? These people are treason. Are you supposed to put up with them? Nah, yeah. That should be the least of her worries. And I didn't mean that as a threat. I mean as a karmic karma she puts out. Yeah, I have no interest in conversing with Claire, but she did give me a good point, and I think that's done, and I'm not really going to talk about that anymore. But yeah, I didn't mean it as a threat, but I mean it's just like you'll be tried for treason. Keep acting like this, you know, like people like that, people like Claire. Let me clarify: people like Claire will be tried for treason. Will be held accountable. Mark my words. It may not be, you know, me or another person, but it might be a higher power, you know. So anyway, I think I am. Holy fuck, that was a long time. Keep rambling, but I don't think there's anything else. Yo, yeah, you're gonna sync my channel for what? I wonder if there's like a. That's what I'm saying, man. Like people don't understand it, and even Pilu. Like Pilu probably has the most knowledge out of all you people. Yeah, I don't know. I don't know why I entertain you people. I think I love you now. I have no shame in that. Spam in my chat. Okay. I think I missed anything. I just don't want to miss anything good. I mentioned something from the Quran. Number 19 on the Jewish Cabal claim prophethood. Okay, that might be for another time. Okay. On these subjects. Who's IC3? St. Michael's, St. George. Some interesting takes here. The highest order given to British officials who work abroad is St. Michael's and St. George. This consists of a star with the little enamel painting. Huh. Interesting. You're not referring to the Star of Remphan, are you? No, I don't think so. Sorry, I'm like, oh, yeah. Most Americans still believe the Reserve is a government. It is not. The fact is a privately owned banking system. Now, here's somebody making good points. Amen. Anga Kong's their Hajj is just to glimpse him. They don't pray, drink alcohol, and deal in usury. In fact, he is a billionaire. Oh, cool. When you hear the truth on earth, you may feel it in your heart, but not in your physical brain. Okay. Oh, this is not bad. I know he's doing religious stuff. Okay. Life is all about. Cool. All right. Cool. Yeah. There's some good things in the chat here. So, all right. I think I'm going to head her out here, and I'm apologize for dragging it on, but thank you guys for joining us, and maybe next time we'll talk about some more religious things. But yeah, thank you to Mr. Pelu, and thank you for everybody who participate in the chat. And you guys have a good rest of your day. Peace out.